Yes.
May, Madam, may I permit to mention for inclusion in the list application, ma'am?
Please come after the vacation. 2 days left only for the revision bench. No, after
Common
that.
list monthly.
After this. Yes.
Let may I be permitted to seek leave to file without certified copy of the impugned order. My lord, the matter is.
What is this? A misappeal?
It is a misappeal because the matter is that my lord, a suit for specific performance was filed before the learned court below. My lord, ad interim injunction was moved, which was rejected. We come to High Court. My lord, High Court passed an order on 16 January that an order of ad interim injunction be passed for 4 months or until further orders.
What are you challenging now?
My lord, we have prayed for extension of the interim order before the court below. They have rejected, so telling that they don't have the my lord.
Not passed any order.
No, my lord.
If there is no order, there cannot.
No, there is an order of the Honorable High
Going
Court.
to obtain the certified copy.
My lord,
No, not you are challenging the trial court's order.
yes, my lord.
If there is no order passed, then how? What can you challenge?
Order is passed. Order is passed.
Why are you trying to file without a certified copy?
But
Obtain a certified
because
copy.
it was passed on 16th May, my lord, we have filed for the certified copy
You get
application.
it, file it.
No, my lord, even the server copy is not available. And the
whenever you get it, only then file it. Without a copy, we cannot take up any order. No.
Ad interim order is
No, unless the order is on the server or it's not uploaded, then it's not an order in the eye of law. You cannot
I have taken inspection. My lord, I have noted the order. My
No,
lord,
no leave. Sorry, no, not like this. Without the copy of the order, we cannot. Yes.
Lordship, may I take leave to mention one matter? Lordship, item number 134 of today's list.
Yes.
Lordship, I filed a CAN application for appropriate orders. Lordship, it will appear on 21 tomorrow.
It is the main matter is about to appear tomorrow.
Lordship, the main matter is today. The appeal is listed today as item number.
It's a connected application. Hand over the slip. Yes.
My lord, may I be permitted to mention one hearing matter? My lord, I am the
No.
This is the appeal of 2016 lower court.
Call on the list. We are just reading the main. However, before parting with the matter, since we disagree with the view taken in Robin Bagchi Supra, we choose to refer the following question to a larger bench to be constituted by the Honorable Chief Justice for resolution. Whether the learned district judge at Port Blair, Andaman and Nicobar Islands has unlimited pecuniary and territorial jurisdiction to hear appeals from all judgments, decrees and final orders of all subordinate courts within the Andaman Islands by virtue of notification number 78/54 dated August 8, 1954, issued by the Chief Commissioner, Andaman and Nicobar Islands, since the operation of the Bengal, Agra, Assam and Civil Courts Act 1887 does not extend to the Union Territory of the Andaman and Nicobar Islands. Insofar as the present appeal is concerned, since extreme urgency has been pleaded by the appellant, we are of the opinion that instead of awaiting the outcome of the reference as indicated above, the file should be directed to be sent immediately to the district court at Port Blair. Accordingly, we hold that this court does not have pecuniary jurisdiction to entertain and hear the present first appeal. Hence, we direct FAT number 4 of 2025 along with connected applications to be transferred to the court of the learned district judge at Port Blair, Andaman and Nicobar Islands for being heard. The file of the said appeal and connected applications, including all papers filed in connection therewith, be transmitted at the earliest to the court of the learned district judge at Port Blair by special messenger at the cost of the appellant, to be deposited within a week from date. It is, however, made clear that we have not entered into the merits of the respective contentions of the parties in the appeal, and it will be open to the learned district judge at Port Blair to decide the same and connected applications on their own merits.
Grateful.
Grateful. Thank you. আমি ওটার পর যদি শেষ হয়ে যায় কি করবো? দিয়ে দিয়েছেন, অ্যানাউন্স করে দিয়েছেন বারে।
Read out for this. The appeal bearing FA number 173 of 2019 is hereby partially allowed. The judgment and decree dated 31st
May 2019, passed by the learned Second Court Civil Judge Senior Division at Barasat in title suit number 1394 of 2015 is hereby modified as follows. The findings of the learned trial court that Baroda Mandal and Baroda Prasad Mandal are one and the same person is upheld. The declaration that the plaintiffs are legal heir of Baroda Mandal alias Baroda Prasad Mandal are entitled to share in the suit property is upheld. The cancellation of the registered gift deed bearing number 7308 of 2014 is upheld to the extent of the plaintiff's 4/5 share in the property. The gift deed shall remain valid only to the extent of 1/5 share of dependent number 1. Learned trial court is directed to take necessary steps to notify the concerned registrar regarding the cancellation of the gift deed to the extent of 4/5 share in compliance with section 31(2) of Specific Relief Act 1963. The issue of partition of the suit property shall proceed in accordance with the preliminary decree already passed by the learned trial court. The application for appointment of a receiver, can number 7 of 2024, shall be considered by the learned trial court in accordance with law, taking into account the findings of this judgment. There shall be no order as to the cost. Let a formal decree be drawn up accordingly. Urgent photostat certified copy of the judgment, if applied for, be given to the parties as expeditiously as possible upon compliance with the necessary formalities in this regard.
Let's see, may I pray one? Let the LCR be sent down at the cost of the respondent.
Automatically.
My lord, may I pray for an order of stay of the order for the time being for 2 or 3 weeks?
Stay of the which order?
The present order.
Judgment.
The judgment, my lord.
Preliminary decree. Oh, this for the period of 6
3 weeks, sir.
3 weeks. Letter on the request on the prayer of learned advocate for the appellant. Let the
Operation of the purchase.
Operation of this order
Of
be
the above judgment and decree.
operation of above judgment and decree be stayed for the period of 3 weeks.
It was the decree.
In this matter, I am appearing for the appellate, my lord. Parties have settled the dispute between themselves amicably, and by the instruction of the appellant is not to proceed with the case. Therefore,
Good.
I am submitting this, my lord. This may be,
The condonation and restoration applications were pending.
this is also pending.
Lord Counsel appealing for the appellant submits on instruction that the parties have settled the matter between themselves out of court. So accordingly, the appellant does not want to proceed any further with the appeal. So accordingly, can 2 of 2025 as well as can 3 of 2025 are dismissed for non-prosecution. Consequentially, FAT 18 of 2017 remains dismissed for default. There will be no arrest to cost.
And my lord,
And filed today be kept on record. What is recorded?
deeply obliged, my lord. In this matter, my lord, I am appearing on behalf of the appellant.
Yes.
My lord, it is at my instance, this matter has come up. My lord, I am facing some trouble because some mistake is committed by us probably. Will your lordship kindly peruse the order dated
Miller, 6th May 2025.
Yes.
Here, Lordship, adjourn the matter. Condonation of delay has been taken out. This is all these things applicable to the state, not to us. As a result of this, Miller, my stay, Your Lordship, granted up to 23rd May, which will appear from 21st April order. So, Miller, in the meantime,
There is only one appeal.
Yes.
yes,
So all this applies to the state means?
Lordship,
All this applies to the state means?
let me state,
Your appeal is not time barred.
No.
my appeal is not there. They have filed so many appeals.
আমার repetition-টা
It was heard in your presence.
Yes.
our appeal was repetition was converted to the appeal,
Appeal.
and your lordship is given liberty to file the formal memo of appeal.
So
We
if
have-
if 1893 is that
Yes,
converted
yes,
appeal.
yes,
Yes,
that.
yes.
And my lords, in the previous order, state was asked for file.
Several matters were taken up together.
They, my lords,
On that date, several matters
no,
were.
no, no, only these matters.
Only
Only
So
these
why
matters.
didn't you point out?
That's why, my lord, it has been, my lord, mistake from our part that it is our appeal, but because the state has been, my lord, represented his appeal, he has asked for time, because in previous order, your lordships were given liberty to file condonation application, the state, in the state appeal,
This appeal is not by the state.
not by
No.
the
So
state.
why didn't you point out? This was taken independently. What
That-
is can one for the stay?
That, yes, state.
Learned counsel appearing for the appellant submits that there was miscommunication, due to which it was recorded in the order dated May 6, 2025, that no application for condonation of delay has been taken out, for which the appellants were permitted to file such application. Full stop. Next para. However, it is submitted that although in other connected appeals of the state, there was delay in preferring such appeals, the present appeal is not time barred and, as such, no condonation application is required. Full stop. Accordingly, let the order dated May 6, 2025 stand recalled. Full stop. Can 1 of 2023 be listed under the appropriate heading?
As regard, my lord, interim order, there
Interim
is
order,
up to 23rd.
23rd.
In the
Achha,
previous
the
order.
interim order granted earlier in connection with Can 1 of 2023
Lordship.
is extended till June 30, 2025 or until further order, whichever is early.
Lordship. Okay, full back.
Poor my lord, Mr. Sukanta Chakraborty is appearing for the appellate.
Yes, sir.
Sukanta Chakraborty.
Achha. Since the relatives of one of us, within bracket Amar Nam, is appearing for one of the parties, let the matter go out of the list on personal ground with liberty to the parties to seek an assignment before a different division bench.
ঠিক আছে
My lord, I am appearing for the appellant. I am led by Mr. Awan Banerjee.
Yes, sir.
Awan Banerjee, my lord.
I
am seeing for short pass.
number one. And my instruction, my lord, matter is appear, my lord. My lord, I have filed an application for my lord appropriate order by recalling the order dated such as 11th August 2022. My lord, kindly see my application.
Why is it appearing under the heading to be mentioned? Why
Yes,
did
my
you
lord,
mention?
I have filed, but the appeal has been admitted without formulating the substantial question of law. My lord, kindly see my.
By us or previously?
No. By
Previously. My lord,
So the application has to appear in the list.
but after admission, matter will goes to the single bench. I have application filed. That
No, if it's a recall application of the division bench's order, it has to come before the division bench.
kindly direct.
Why to be mentioned?
But-
Should have mentioned the application directly.
Yes, my lord.
What is the number of your application?
Can two. It will be listed under the heading application.
Recalling the order for division bench has to come before us.
Yes, my lord.
I am for the respondent number 2.
Right. You are for respondent. Which
Respondent number one.
Learned counsel for the respondent number 1 submits that an application for recall bearing Can 2 of 2023 has been filed by the respondent since no substantial questions of law were formulated at the juncture when the appeal was admitted by a different division bench. Full stop. Next para. Let Can 2 of 2023 be listed under the heading application tomorrow.
Okay.
Mr. Banerjee, come prepared on
My
order for
lord,
Rule 11
yes,
also, because
I shall
while
come.
hearing the
Because
application, if
questions are-
required, we shall. আপনার কাছেই তো ফাইল থাকবে, আপনি খুঁজে পাচ্ছেন। Not today, the file is not being traced out. So if it's not found out, we'll lodge a diary in the police station.
Acceptable. Tomorrow it may be.
Tomorrow, yes, yes, only not today.
Okay.
Yes.
This is the
আমাকে রিপোর্ট দেবেন একটা রিসেসের মধ্যে।
Lordship, I am for the respondent.
Yes.
my lord, I'm for the appellant petitioner, my lord. My lord, kindly takes up, my lord, page 37. There is a map in the stay petition.
Why is it appearing specially fixed? You mentioned it.
Yes, I mentioned it yesterday, my lord. Around 100,
Urgency.
100 students are studying
Oh, yes.
in the age of 2 to 5 years.
Page.
Page 37, my lord.
You are a school or what?
Yes, the appellant is the owner of a school which runs a Montessori school. My lord, in the map,
Page 37, yes.
page 37, yes, my lord. My lord, there are lot A, B, C.
Right.
My lord, D, D, and D.
First, tell
And
us what the appeal is about.
Yes.
The appeal is
Well,
against what?
Appeal is against refusal of a temporary injunction. Injunction was already there for 1 year. Thereafter, it was vacated. Why it was vacated, I'm coming. But the facts of the case,
Map.
well,
Yes.
this map, well, the common space is governed by a decree of 1945. And then in the decree, there was an arbitration award which culminated into a decree passed by this Calcutta High Court. And it said that this common space has to be used by everyone and nobody can encumber this common space. So it has to be used by everyone. Now, my lord, A, B, and C, they are not giving any trouble to the appellant, who is the Montessori school in 94. This is 94B, middle portion.
Right.
Now, 94A on the left hand side, 94A, Iliatod, Arsad Hussain, and others, they are causing trouble in this common space by blocking the common space with vehicles, with highly inflammable adhesive containers.
What do they do there?
They run a business. And the photograph is just
Business of adhesive.
adhesive. Next page is the photograph. Page C. Well, kindly sees how the blockage has been done in front of the garage, school's garage, and as well as the school.
Which is the garage? The one with the grill.
One in the grill, my lord.
Right.
My lord, in the map also on the left hand side, school garage is written. Page 37.
True.
School garage and the school.
All right.
And my lord, here, my lord, vehicles are at page 116. Few more photographs are there. Page 116, page 117, page 118.
All right.
Well, there is also a report of the police because we had filed a 144. There is a recording of the magistrate that the school authorities are facing problem. I shall place that order, which is at page 137.
Then what happened?
My lord, thereafter, my lord, what happened that once, because this is an old property, my lord, we were carrying out, why the dispute arose? We were carrying out some repair work in the garage, my lord. So they filed a complaint, my lord, and then they started disturbing that you cannot carry on the repair work. They have filed a 144 where the after investigation it was found out that no unauthorized construction was being done. Simultaneously, we also filed a 144 where it is the recording that the school authorities are facing problem and they are parking their vehicles, admittedly. But we filed a suit before the city civil court.
Declaratory suit.
Declared suit and for injunction.
Declaration regarding what?
Declaration that the plaintiffs can enjoy their property peacefully and can carry out the repair work. This is what. And
nature of injunction?
And a temporary nature of injunction that the respondents should not disturb or should not park their vehicles. Well, the injunction granted is at page 121.
ad interim was initially refused.
No, there first injunction was granted. Thereafter, when you filed the contempt application, the injunction was there for 1 year, more than 1 year. When you filed a contempt application, it was pointed out by the London City Civil Court that the description of the premises is not properly given in the suit. So we had to withdraw that suit and file afresh. When we filed afresh and then moved the injunction again, praying for the same injunction, that was first refused by saying that the respondents need to be heard, the defendants need to be heard. And thereafter, when we served a notice to the defendants, well, the defendant did not appear, only defendant 1 appeared. And for defendant number 2, although they are residing in the same place, in the notice it says, in the written, it says that the item could not be developed because the address could not be found. The defendant number 1 received but for the sons, the remark was there. But thereafter, when we moved the ex parte and it was refused, thereafter,
This appeal has been admitted.
Appeal not admitted. Today is the first time we have.
Let us see the impugned order once.
Yes. Impugned order is at page 34.
What is this? No injunction order can be issued as it will affect persons who are not parties?
Yes. The London trial court is saying subsequently, first, the same court granted the injunction for 1 year, and then thereafter refused the injunction by saying they need to hear the defendants. When the defendants appeared.
This map is annexed to your.
Yes. Now they are saying that for lot A and B, C will be affected. If by the same decree of the Calcutta High Court of 1945, everybody.
They are parking in front of your school garage. ABC will not be affected.
Correct. This is my point.
Yes, what do you say?
Lordship, before setting up their school, I am running my business.
Maybe there's a common right by a decree of court. It's a common passage by a decree of court.
Lordship, I am not using the common passage for my vehicles. And Lordship, the loading and uploading of goods is being done in my garage. And Lordship, kindly allow me.
You cannot park your vehicles in front of the garage.
No, Lordship, kindly, Lordship, allow me to place a few photographs. Lordship, this is the garage.
These are part of your written objection in the court below. The injunction application has finally been decided.
Well, they did not file the written statement. Well, the suit is ex parte.
Lordship, written objection has not been filed.
Then, how can you rely on documents? The court has to proceed on the basis of their application. And let us see the photograph.
Lordship,
for curiosity's sake.
My garage. And Lordship, this is
the
the common passage, and Lordship, kindly see how they are encouraging the common passage by extending the part of the shade.
You prefer, you seek an injunction for that. But you cannot park your car in front of the school gate.
Lordship, I am not parking any car in front of the school.
Then you will not be affected by the injunction. Let us grant that injunction. Where is the prayer for injunction? Your prayer before us is similar to that of the court.
Same prayer.
এই ফটোগুলো ফেরত দিয়ে দিন। Repair work we won't permit right now.
No problem.
But this B will grant men and school children by parking cars and blocking storing inflammable material adhesive. You cannot store containers adhesive material on the.
No, Lord.
So grant that injunction. So should you dispose of the appeal itself? Either we dispose of the appeal or keep the appeal pending, and we'll grant that injunction in any event.
Lordship, dispose it.
I will dispose of on consent of parties. We take up both together, appeal and the application. We dispose of and direct the what is the suit? 2024 suit. You cannot direct. We'll express our hope that it will be decided expeditiously. Only that.
Well, my prayers are at page 152.
Page 31 will go by B.
Yes.
The grievance of the present plaintiff is that by a previous decree dated June 6, 1945, the common rights of the parties stroke their predecessors was decided in respect of the suit passage, which is marked by the letter E in the sketch map annexed at page 37 of the present injunction application. Full stop, next para. It is contended that the said sketch map was a part of the papers before the trial court. Full stop. Next para. It is submitted that the defendants, who own an adjacent plot to the school which is being run by the plaintiff, are disturbing the ingress and egress of the plaintiff to such school, as well as blocking the parents, guardians, teachers, staff, students, and others to the said school by parking cars and stroke or blocking the entrance to the garage of the school by storing commercial adhesive containers which are inflammable in nature, as well as rubber sheets. It is argued that initially a suit was filed where injunction was granted. However, subsequently the said suit was dismissed with leave to file afresh in view of the description of the suit property being vague according to the learned trial court. With such leave, the present suit has been filed for declaration of the plaintiff's right over the common passage and for permanent injunction in aid thereof. In the suit, an injunction application was filed. By the impugned order, the learned trial judge has refused such injunction on the ground that by virtue of a previous award of arbitration proceedings, the common passage described in Schedule B of the plaint within bracket marked as Lot E in the sketch map referred to above bracket closed are in common use of the plaintiff, defendants and other owners of the adjacent premises situated by the side of the said passage and falls in lots A, B, C, and D, and no injunction can be issued as it will affect the persons who are not parties to the suit. Next para. However, we find from the sketch map in question that the injunction sought by the plaintiff stroke appellant, if granted, cannot have any bearing on the user of the passage by third parties and stroke or create any blockage to such user by either the present parties or the adjacent owners. The nature of the injunction is confined to alleged blockage of the entrance of the school run by the plaintiff by the defendants and as such is restricted to infringement of the legal right of the plaintiff to run the school by disturbing the ingress and egress thereto. Hence, the premise on which the injunction was refused is not sustainable on the facts of the case as well as the law governing the field. Next para, rather, in view of the extreme urgency involved, since the plaintiff is running a school and the outcome of the present appeal would affect the fate of several students, staff, teachers, and their guardians, we are of the opinion that a sufficient prima facie case has been made out by the plaintiff stroke appellant for grant of injunction, on the strength of the decree passed in 1945 and the arbitral award leading thereto. In such view of the matter, we give a proposal to learned counsel as to whether we shall take up the appeal itself for hearing along with the application, to which learned counsel for both sides, in their usual fairness, agree. Accordingly, we admit the appeal and take it up for disposal. In the light of the above observations, FMAT 142 of 2025 is allowed on contest, thereby setting aside the impugned order bearing order number 14 dated March 13, 2025, passed by the learned Judge, comma, 5th bench, comma, City Civil Court at Calcutta, in title suit number 1370 of 2024, and hereby grant injunction restraining the defendants stroke respondents and stroke or their men and agents from from blocking the ingress and egress to the suit property which belongs to the plaintiff by parking cars, comma, storing highly inflammable commercial adhesive containers and rubber sheets, or in any other manner whatsoever till disposal of the suit. Full stop. It is expected that the learned trial judge shall make endeavor to dispose of the suit itself as expeditiously as possible without granting any unnecessary adjournment to either party. Full stop. There will be no orders to cause urgent satisfaction.
Lord,
Can 1 of 2025 is disposed of accordingly as well.
Lordship, only one point. Lordship, kindly mention in the order the common passage will be free from the bikes and cars of the guardians also.
You have not paid for an injunction. File an injunction, get an order.
No.
You are equally entitled.
Lordship.
If they are blocking your egress, then you are equally entitled to it. And you can cite this order, in fact, for getting that injunction.
My lord, only one thing, my lord, the FMA number is already available. It's FMA
Thank you. FMA টি না হয় এটা FMA হবে একটু দেখে।
733 of 2025.
733. তাহলে FMA 733 of 2025. Thank you.
Lordship, Mr. Honorable Bhattacharya is
One second.
appearing.
অনিন্দে এটা judgment form এ হবে। Yes. Mr.
Mr. Honorable Bhattacharya is appearing for the petitioner.
Yes.
Is unwell, and due to of his illness, he is not coming to court. Kindly keep this matter after vacation.
On the you are for the appellant.
And yes, I am for the petitioner.
On the prayer of the appellant stroke petitioner, let the matter stand adjourned till after the upcoming summer vacation of this court and be listed in the monthly list of June 2025.
I have prepared the chart
Right, file
of your lordship's direction
Okay.
regarding the service, my lord. 70 respondents.
Yes, is that one.
Out of 70 respondents, my lord, 61 have been delivered by hand and by speed post, and others, my lord, yet to be delivered.
Which of them did not contest in the court below? Not delivered ones? Yet to be delivered?
Yes.
Only 6, item 6.
6 or 8. 20. Only one page is there.
Yes, item 6.
Item 6, yes.
Achha. So, did they contest in the court below?
No, no.
That is what we asked you to ascertain.
I will day after tomorrow. Will kindly take this matter day after.
Day after tomorrow, we will be taking up appeals. Have you filed your affidavit of service?
Yes, this is my by tomorrow, my lord.
Tomorrow, do it tomorrow. Just ascertain which of these people did not. Learned counsel appearing for the appellant submits that out of the 70 respondents, comma,
61, one is expunged in the learned court below. Respondent number 2.
Almost all have been served,
Yes.
comma, apart from pro forma respondents 25, comma, 27, comma, 28, 34, 40, 42, 44, and 45, who have not been served as yet. Full stop. Learned counsel hands over a chart indicating the parties who have been served, which is kept on record. Full stop. Learned counsel for the appellant is requested to ascertain as to which of the unserved respondents did not contest the suit in the court below. Full stop. For such purpose, comma, let the matter stand adjourned for the day. Just check up which of item 6
yes,
people did not contest in the
Yes,
court.
yes.
You'll find from the decree itself.
Yes.
Just check up
Yes.
with that number. হ্যাঁ তুমি দেখলে না যখন মিলেছে তখন তো দেখবে যখন দেখে নিতে হবে তো অ্যাডভোকেটের কোনো মেয়ে দেওয়ার সময় একটু দেখে নিতে দিয়ে তার নাম দিয়ে দেবে আমার আবার নাম দিবে Next.
Still, my lord, I am for the applicant. My
Yes.
lord. Well, this is an application for expeditious disposal of an appeal, which is pending before your lordship. Your lordship yesterday wanted
Stay
to.
application has been allowed.
Yes, my lord. No, stay application was allowed, my lord. And it was, your lordship wanted to know whether it has been served, my lord. In the order itself, it is stated that first it was served, they received it on 3rd of July 2023,
The
my
other
lord.
applications have been disposed of.
No, my lord. Yes, other disposed of.
Only can 3.
10-4.
Can 3 also for expeditious disposal?
Yes, that was also for that was also served. That was also served. And now the latest application, which is pending.
Why are you making so many applications? Can 3 would suffice?
My lord, yes, that would, but
Can 3 is
So-
still pending?
this is the latest for expeditious disposal
We
along with.
want to know which of the applications are pending now.
My lord, I think
You
can.
have to dispose them also. Otherwise,
So
the
can 3 is that expeditious disposal is that is the pending, my lord.
no, 1, 2, 3, 4 all are pending.
Stay is
No, my lord.
can 1.
2 was their application. 2 was my stay application, my lord. And 3 was their application for vacating.
What about 2 and no, 3 was not vacating.
You are
1 was stay application, 2
1
was
was stay
vacating.
application, 2 was vacating.
What happened to those?
My lord,
Unless the applications are disposed of,
my lord,
the appeal cannot be disposed.
my lord, those were disposed of, my lord.
When?
My lord, on 16, my lord, if your lordship kindly come to the order dated 16/10
of October.
of Honorable Justice Tandon, my lord.
Yes, let us just check.
That was stay was granted.
Application was made returnable 1 week after vacation.
Yes, my lord. Stay was granted, my lord. Kindly see.
Application was not disposed of.
No, application was not this, but the next order, my lord, the last order, when the vacating application was there, my lord, then
We wanted to know when it was disposed of. That is all we.
no, that was not. Those were not formally disposed of, my lord.
Then we're asking you.
And so I am praying for expeditious disposal, my lord. The fact is, many things happened in between.
No, we cannot direct the appeal to be disposed of unless the applications are heard out.
My lord, let the applications be heard
You were
out.
noticed to the other side, they're not happy.
My lord, I have served. On the last occasion, they appeared. Thereafter, when I went to give the notice to the learned advocate for the other side, my lord, he said that he is no longer appearing in this matter. So we have directly served the party, my lord. This is the affidavit of service. আরেকটা কপি কোথায় গেল? একটু নিয়ে নিন এটা। Second copy. Let the LCR be called for so that a paper book can be prepared.
Injunction application has expired already.
Yes.
So there is no injunction now.
No injunction now. My lord, the fact is this: during the pendency of the stay application, we have Honorable Justice I.P. Mukherjee passed an order on the 20th of June to serve copy and come back. It was made returnable on 3rd of July. I have served the copy of the stay application and they have received it on the 3rd of July. My lord, affidavit of service is there in the lordship's file. And thereafter it was pending, and in the meantime, after receiving of those, they proceeded with the execution proceedings. And then they informed that after when they filed an vacating application on the ground that execution proceeding is completed, my lord.
So you don't want to proceed with Can 1?
My lord, of course I want to proceed, but my lord, now what is my relief? Because they have already completed the execution proceeding, but not to give effect to, I can. Then they have received all the copies, my lord.
Position.
No, not yet.
Then if you don't have any stay, you will be ousted before the application.
Yes, my lord. That is also a problem.
You have
So
to
I want to
your
proceed.
application.
Yes, my lord. I want to proceed with that, and as well as I want to the speedy disposal of this appeal also, because
once it is stated that stay order was passed, and again it is stated by another division bench that injunction was vacated.
the stay by the same division bench, my lord.
Yes, what was passed, injunction or stay?
Stay. My lord, kindly see the order dated 16th of October.
We have seen that, but there are subsequent several orders.
There is only another. There is only another order.
No, 2 orders.
Two order.
16th October 2023.
Yes, my lord. After that, there is a vacating order. The file was returned to the department.
No, then 12th of December 2023, there is another
An
order.
extension. There was an
Interim
extension
order
of
be
the
extended
of
till
till
the end
30th
of January 24.
Yes,
Now that has expired now.
that
Why
has
didn't you
expired,
ask
my
for extension?
my
If
lord.
you
On that
evicted,
day, what happened? It was so unfortunate for me, my lord. When the order was just dictation was completed, I entered because it was item number 2. I could not reach in time, and so Justice Tandon said, since I have passed the order, you
Mr.
proceed.
Kolol Basu and Mr. Shomik
Yes.
Sarkar are appearing.
They were appearing. When after filing this application, when I went to serve notice to Mr. Shomik Sarkar, he said that he has retired from that from this matter. So we have served the party directly, my
Where
lord.
is that?
That I have just filed the affidavit of service.
You have filed.
Yes, just now.
Can 1, 2, 3 dispose of করে দিই?
My
তারপরে
lord, kindly.
দিতে পারবো।
And if your lordship kindly give me some relief, be pleased to allow some relief so that possession cannot be taken unless and until the appeal is disposed of.
No, this is against eviction suit.
My lord, it's a suit for specific performance of contract, my lord. It was filed against the predecessor of the appellants, my lord. Husband of the appellant number
Can
1.
1 of 2023 is an application for stay of the connected execution case whose of the appeal arises out of a decree of specific performance of contract. Whose of next para? Learned counsel for the appellant submits that when copies of the applications were sought to be served on the learned advocate who appeared all along for the respondent, the said learned advocate refused to accept the same on the ground that the client has taken the brief from him. Accordingly, copies of the applications were served directly on the respondent, regarding which an affidavit of service is filed today. It transpires that the service has duly been effected on the respondent. As such, we take up the pending applications for disposal. Can 1 of 2023 is an application for grant of stay of the connected execution case, and can 2 of 2024 is an application for vacating the ad interim stay initially granted. In view of the stay order having in the meantime expired, can 2 of 2024 is disposed of as infructuous. Can 1 of 2023 is now taken up for hearing. Although the ad interim order expired in the meantime, since we are taking the main application, the expiry of the ad interim stay does not have any direct bearing. On an independent consideration of the case made out in the appeal, we find a strong prima facie case for hearing of the appeal on merits has been made out. Accordingly, can 1 of 2023 is allowed, thereby granting stay of all further proceedings of title execution case number 4 of 2018 pending before the learned civil judge, senior division, second additional court at Bardwan district. Which district? This is Purba Bardhaman. District Purba Bardhaman in title suit number 31 of 2013 until disposal of the appeal. Can 3 of 2024 as well as can 4 of 2025 are both applications for expeditious hearing of the appeal. In view of the innocuous nature of the prayers made therein, we choose not to direct further service on the respondents, more so since they choose not to appear despite service. Accordingly, can 3 of 2024 as well as can 4 of 2025 are disposed of by directing the appellants to put in requisites and postal costs for service of notice of the appeal on the respondent within a week, within June 13, 2025. The trial court record shall be brought by special messenger at the cost of the appellants also to be deposited by June 13, 2025. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants, who have liberty to the parties to mention for inclusion in the list as and when the appeal is ready for hearing.
Grateful to your lordship.
Thank you. No orders to cost একটা করে. Please give whoever your names, whoever is appealing.
Lordship, I'm appealing for the appellant, On the last occasion, there was a direction for serving. Only one respondent was left out, Your Lordship.
Yes.
We have served upon her and she has received it. Lordship, there were two applications pending. One was being CAN 5 and one was CAN 6. CAN 5 was for Order 41 Rule 27. That too has also been served upon all the respondents again, my lord.
Yes.
And
CAN 6?
CAN 6 was for that substitution. That was done at a later phase and that was pending, my lord. And we have solved it.
Just give us the background of this substitution. It's couched as Order 1 Rule 10. Why?
Lordship, since one of the plaintiffs who was appearing before the learned trial court,
this is a suit of partition.
Suit for partition, my lord.
You have challenged a preliminary degree?
No, my lord. Final degree.
Final degree granted against you?
Yes, my lord.
So this person died during pendency of the suit?
Suit itself, my lord. But they didn't participate in the before the learned trial court. Now what happened, my lord? Initially, it was served upon us. We filed the wakalatnama, but ultimately we didn't contest the matter. What it came from the order itself, that initially the wakalatnama was
that
filed.
does not prevent you from filing an appeal, but you left out this person in your memorandum. Affidavit of service filed to be kept on record. It transpires from the affidavits of service which are on record that all the respondents have been served. However, the respondents choose not to appear. Next para. CAN 5 of 2023 is an application for production of additional evidence under Order 41 Rule 27 of the Code of Civil Procedure. As per the established practice of this code, let CAN 5 of 2023 be listed for hearing along with the main appeal. Affidavits, if any, shall be exchanged in the meantime. Next para. CAN 6 of 2023 is an application for addition of one Sudipto Mitra, in place of the deceased respondent number 5, namely Sholil Mitra. Learned Counsel for the appellant submits that although the said Sholil Mitra had met his demise during pendency of the suit, and his heir had been substituted.
My lord.
His heir had been substituted in the suit, the said heir was left out inadvertently in the appeal, and instead of the heir, the name of the deceased was mentioned as respondent number 5 in the memorandum of the present appeal. Next para, keeping in view that the said that the heir of deceased respondent number 5 was already impleaded in the trial court, and that in view of the nature of a partition suit from which the present suit arises, where the cause of action is continuing and the concept of substitution does not strictly apply, we are of the opinion that the present prayer ought to be allowed. Accordingly, CAN 6 of 2023 is allowed, thereby directing the substitution of the name of Sudipto Mitra in place of the deceased respondent number 5, Sholil Mitra, consequential amendments to the cause title of the appeal, memorandum of appeal, shall be carried out by the learned advocate. Any other application is pending?
No, my lord.
Shall be carried out by the learned advocate on record for the appellant during the course of the day.
My
lord. Thereby introducing the name of Sudipto Mitra and expunging the name of the deceased Sholil Mitra. The appeal is otherwise, there is no pending application.
No.
So we'll give the directions, those directions, other directions.
Lordship.
The appellant shall put in requisites and postal costs for service of notice of the appeal on the respondents, including the newly added respondent, within June 13, 2025. The trial court records shall be brought by special messenger at the cost of the appellant, also to be deposited by June 13, 2025. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Grateful. Thank you. Lordship, the paper books are ready in this matter because once the
trial court records are there.
Yes, my lord.
Paper book ready, then you have to point that out.
Lordship, unconditional
service of notice has been.
Lordship, it was effected. Only these applications, those were filed subsequently. Those were not served.
Lastly, shall deposit postal cost first the appeal be listed in the monthly list of July 2025.
Grateful.
Item number 12, short passport.
Both. Then not to date. On the prayer of the parties, let the matter stand adjourned for the day.
Well, item number 13, my lord, I am appealing on behalf of the appellant.
Is there?
There is a affidavit.
Yes.
I'm filing the affidavit. My lord, the appeal is ready for hearing. Only my lord has granted the interim injunction that my landed friend clients will not alienate the property till the disposal of the appeal. Well, my landed friend's client is in a possession.
No, the injunction is now till the disposal of the application or the appeal.
The application. The application.
You're enjoying an injunction. What is the difficult? Later come back. Then we'll keep it after the vacation. An adjournment is sought on behalf of the which respondent?
Just 1 minute.
Respondent number 1. There are many respondents.
Krishna Kumar,
अपनी वकालत नामा देखना.
opposite party number 1, Krishna Kumar.
The counsel appearing for the respondent number 1 seeks an adjournment in the matter. Full stop. Accordingly, let the matter stand adjourned till after the upcoming summer vacation of this court and be listed in the monthly list of June 2025. You are enjoying that injunction till disposal.
But till the disposal, till such period, my lord is granted the injunction, my lord.
Not till disposal of the application.
Perhaps, my lord.
Till such period, we don't grant such injunction.
I beg your pardon.
Must be still disposal of that, unless it's for a limited period.
I'm grateful. I'm grateful.
But I am for the appellant petitioner that your lordship granted an interim protection in this milord appeal. It's arising out of a matrimonial proceeding. Now, milord, that was for a limited period.
Paper books, Mr.
Milord, that's that. Milord, the LCR come. Milord, what happened, milord, regarding the milord documents that has been relied upon by the wife, that is not with me. If your lordship allow me, milord, to take a certified copy of from the milord documents, milord, the law court record has already arrived.
Prepare paper books, it will be a part of the paper books.
Milord, the documents, milord, is not with me. The document relied upon by the wife before
It not be with you. It is prepared through the court. They take an inspection of the court. Whoever prepares the paper book, you know that.
Yes, but milord, your lordship.
Why should you have separately those documents? Those are a part of the records and be part of the paper books.
Milord, the department is not, milord, the preparing the paper book. It's outside.
Whoever prepares, they go to the department, give an inspection slip. You have grown too senior.
Inspection slip, milord, it's not, milord, that. Milord,
they go and have an inspection and take out copies, and only then the paper book is prepared.
That's why, milord.
Otherwise, how do they prepare the paper
that
books?
will take some time. That's why, milord,
No. What is the question of certified copies? What is the application for?
The application is, since your lordship already disposed of the CAN application by granting a limited, milord, interim order and granted leave, milord, to file an application, milord, if necessary. Milord, application is for extension.
When was it granted till?
That was not granted till the 31st March 2025. Thereafter, once the matter appeared, but without any application. Your lordships of the view, since there is an express, milord, opinion of
what was the interim order granted?
Milord, interim order granted, milord, till the decision of this appeal. There are two proceedings. Section 9 proceeding filed by the milord my client that was dismissed, holding some, milord, observation.
Divorce suit is pending.
Divorce suit is pending. Milord, your lordship state that.
We stayed or prior to us?
No, milord, your lordship's order.
Let us see the reasoning.
Yes, milord, if your lordship takes up, milord, in my application for extension, I have annexed, milord, your lordship's order.
What is the date of that order?
Yes, milord, it is, milord, 2nd of December 2024. Page 7 of my application, CAN 3, milord.
Oh, 4 years after your suit?
Yes.
Then section 10 will also be applicable.
Yes, that's your lordship.
Yes,
also,
section
milord,
10 was
yes.
There. Yes, Mr. Banerjee will reimpose. Appeal is ready for hearing, otherwise?
Milord, only the paper book. Otherwise, it's ready for hearing.
The records are here and
records are here, milord. My learned senior friend has already appeared, so no.
You have to file paper books.
Only paper book. Your lordship gives me 4 weeks time, milord. By that time, my junior will prepare.
CAN 3 of 2025 has been filed for extension stroke reimposition of the interim order granted earlier. First of we find from the records that Initially, an injunction, a stay was granted in connection with a connected matrimonial suit. Full stop. The appellant husband filed a suit for restitution of conjugal rights under Section 9 of the Hindu Marriage Act. Full stop. The same being dismissed, comma, the present appeal has been preferred. Full stop. 4 years, next para. 4 years after the filing of the suit of the husband, comma, the respondent wife also filed a divorce suit, which is now pending. Full stop. Since the principle of Section 10 of the Code of Civil Procedure is applicable and the present appeal is deemed to be a continuation of the husband's suit for restitution of conjugal rights, comma, we, comma, upon an independent consideration for the purpose of reimposition of stay, comma, are still of the opinion that a prima facie case for hearing the appeal has been made out, and unless the connected divorce suit of the husband is stayed, comma, the present appeal may be rendered infructuous. Full stop. Accordingly, Can 3 of 2025 is allowed on contest, comma, thereby reimposing the stay order granted on December 2, 2024 and granting stay of all further proceedings in matrimonial suit number 43 of 2020. Matrimonial suit number 43 of 2022 pending before the learned additional district judge, comma, second within bracket fast track bracket close court, comma, at Kalna, comma, district Purbo Bardhaman till disposal of the appeal. Full stop. It is, comma, however, comma, made clear that this order of stay shall not prevent the learned trial judge in connection with matrimonial suit number 43 of 2022, comma, to take up all interlocutory applications pending in connection therewith. In the meantime, full stop. Next para, the appellant shall prepare paper books in connection with the present appeal within June 30, 2025. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. We are giving you much more than 4 weeks.
Great. Extremely.
Yes, Mr. Bodal, what is that?
Pursuant to my lord's direction on 7th of May 2025, and I have filed an application seeking leave.
So you are not a party in the court below?
The respondent of the appellant number 2 to 5 were not parties before the court below.
Oh, yes.
I filed an application.
You have served copies on that, and we did not direct.
My lord's view was not to serve. There was if my lord takes up my lord's order.
Achha. Regarding the leave, no copies required.
No, my lord. If my lord takes a paragraph, hence we construe that the respondent is deliberately avoiding service, my lord.
You had sent previously?
Previously, I had sent the other applications, my lord.
Achha.
He was refusing to have. Letter is being where eviction notice has been issued upon the appellant.
What is the ground for adding them as parties here, appellants?
My lord, they are the beneficial objectors.
So why were they not parties in the court bill? It was your suit.
It was no. It was a grant for application for grant of probate, my lord. The petition, the appellant.
That has been granted. You have challenged that.
Challenged.
Achha. So why were they not parties there?
My lord, after the hearing was concluded, my lord. After the hearing was concluded, the respondent, the appellant number, the father of the respondent number, the husband of the Rupa Chaudhary expired, my lord. Rupa Chaudhary expired.
One Asha Singh was already on record.
Asha Singh was already on record. She is one of the objector, and his brother Rupa Chaudhary was one of the objector. The sons of the testator, my lord. Sons and daughters of the testator.
And Asha and Rupa, what are they?
Brothers and sisters. Asha Singh is the sister of Rupa Chaudhary.
Rupa was a male.
Rupa was the male. Rupa Chaudhary, alias Rupesh Chaudhary. There's a Can 1. I have filed Can 4 of 2025 seeking leave to.
First, let us allow that. Can 4 of 2025 is an application seeking leave to prefer the appeal on behalf of the appellant numbers 2 to 5, comma, who were not parties in the court below. After the conclusion of the hearing in the probate court, comma, against the grant of probate in which the present appeal has been preferred, comma, the Rupa Chaudhary, comma, one of the objectors apart from appellant number 1 in the proceeding, comma, met his demise. Full stop, next para. Accordingly, comma, since the death occurred after the conclusion of the hearing, comma,
Expired on 15 July 2021, madam.
that is not after the date of
After hearing was concluded.
comma, the law presumed that the decree was passed also in respect of the deceased. Full stop, next para. The present appellant numbers 2 to 5 are the heirs and legal representatives of the deceased Rupa Chaudhary, comma, who died on July 15, 2021. Full stop, next para. As such, comma, since the appellant numbers 2 to 5 have stepped into the shoes of the said deceased, comma, being the children of the testator,
Wife, widow and the children.
being the widow and children of the testator respectively, comma, we
Being
are
the respondent number one, being respondent number 1.
2 to 5, they are children.
No, grandsons and daughter-in-law.
Being the children, wife na kore, being the heirs of the deceased testator otherwise, comma, can 4 of 2025 is allowed, comma, thereby granting leave to appellant numbers 2 to 5 to prefer the present appeal. So what are the other applications? Can one is condonation?
Condonation of delay.
What is the delay?
606 days, my lord.
Explanation?
From paragraph 15, given the explanation, my lord, the Rupa Chaudhary was looking after the case. He was suffering from cancer, went to Vellore, my lord. They were not aware of who was conducting the case, my lord, before the
Asa Chaudhary was there.
Asa Chaudhary is a lady, my lord. She used to
Ladies cannot conduct cases.
not conduct the case. That is not the reason, my lord. Since he was relying on his brother, my lord, and mentally shattered down after that demand. All of a sudden,
Mentally shattered for 600 and some days, and only then she.
Thereafter, they came to learn that, my lord, if my lord takes a paragraph.
But Asa filed her independent written objection also.
No, jointly. It was jointly. Written objection was filed jointly before the trial court.
You have annexed that?
Yes, yes.
Where is that?
My lord, is as page 34. Page starts at page 33, my lord. It was jointly, my lord. Page 34. Affidavit in opposition on behalf of the relation number 1 and 2.
Right. Can 1 of 2024 is an application for condonation of delay. First up, in our earlier orders, comma, we have already recorded that the respondent was deliberately avoiding service and constitute good service to have been effected on the respondent. Full stop. Accordingly, we take up the application for hearing. Full stop. The appellants have pleaded in the application that the deceased Rupa Chaudhary, comma, who expired prior to passing of the impugned probate decree, but after the conclusion of the hearing therein, comma, had been all along conducting the case on behalf of both himself and appellant number 1, Asha Singh, comma, who were the joint objectors in the probate court. Who's up in the testamentary court, comma, as we find from the annexures to the application, comma, a joint written objection was filed on behalf of appellant number 1, Asha Singh, and the deceased Rupa Chaudhary, comma, which was signed and affirmed by the said Rupa Chaudhary. Full stop. Thus, comma, we find that it was the deceased Rupa Chaudhary who, during his lifetime, had been conducting the case on behalf of both the objectors, namely himself and Asha Singh. Full stop. The appellants plead that after the demise of Rupa Chaudhary, comma, they were not aware about the court proceedings and the papers regarding thereof, comma, since Asha Singh was not conducting the case at any point of time. After long search, comma, they came to know of the details of the matter and thereafter preferred the appeal. Upon perusal of the uncontroverted allegations made in the application for condonation of delay, comma, we are satisfied that sufficient cause for the delay has been made out. Accordingly, can 1 of 2024 is allowed, comma, thereby condoning the delay in preferring FAT 275 of 2024. Full stop. There will be no orders to cost. The appeal is deemed to stand registered and admitted. Any other pending application?
And can 3 is there. Can 2 is for injunction, my lord, restraining the respondent from disturbing the possession of the property.
And can 3 is also for injunction.
Can 3 is for receiver, my lord. There are
Can 2 is for receiver. It's the other way around.
injunction, my lord.
No, you wrote it wrongly. Or the main copy says can 2 is corrected. Receiver, where is the question of receiver?
My lord, there are tenants over the property, my lord. There are certain tenants.
So
my
that
lord.
would be an administrative pendentility scenario. We are not satisfied with that. What sort of injunction have you asked for?
My lord, I have sought for injunction, my lord. And the prayers are from transferring the property, my lord. The prayers are at the difficulty is the tenants are paying their disturbing the tenants who are coming to the appellants to whom they would pay the rent. That is the whole difficulty, my lord. And he is forcing the tenants, the respondent is forcing the tenants to
We direct the respondents to put in quarterly accounts. Quarterly accounts. If they fail, then you can come up
the
and
respondent is only there is only one respondent, my lord.
yes, we'll ask him to furnish quarterly accounts with copy to you before this court.
And
Finish. And what?
my lord, therefore the injunction, my lord, not to transfer the property.
Injunction will run. Can 3 of 2024 has been filed seeking injunction in respect of the property which is the subject matter of the impugned will. For since a prima facie case for hearing the appeal on merits have been made out, comma, can 3 of 2024 is allowed, comma, thereby restraining the respondent and his men and agents from selling, transferring, alienating, and or encumbering the suit property in favor of third parties, encumbering the subject property in favor of third parties in any manner whatsoever till disposal of the appeal. First up, there will be no order as to cost. Next, can 2 of 2024 is an application for appointment of receiver. First up, necessarily, comma, a prayer for receiver in connection with a testamentary proceeding tantamounts to appointment of an administrator pendentility. First up, it is alleged in the application that the respondent has been exclusively collecting rent from the rent and usufructs from the tenants in the property. First up, as such, comma, it is submitted that administrator pendentility stroke receiver be appointed to collect such rent. First up, next para. However, comma, at this juncture, comma, we do not find that a high ground of appointment of an administrator pendentility has been made out. First up, however, comma, we direct the respondent to file quarterly statements of accounts indicating all the income and expenditure from and in respect of the subject property covered by the will by way of an affidavit with the learned registrar general of this court. First up, the first of such affidavits, comma, for the quarter from April 1, 2025 to June 30, 2025 shall be filed by July 15, 2025. First up, an advance copy of each of such quarterly statements shall be furnished to the learned advocate for the appellant. First up, can 2 of 2024 is disposed of in the light of the above observations without an order as to cost. The
respondent is not appearing, avoiding the service. Can the appellant place this or my lord's order in the main door of the premises, my lord?
No. Nothing.
You won't have, my lord, this one order. I have to.
No, don't paste anything. You can copy but not paste. I will direct you to so that the appeal is prepared. The appellant shall put in postal costs and requisite for service of notice of the appeal on the respondent within June 13, 2025. The trial court records shall be brought by special messenger, and the original will shall be kept separately in the custody of the Registrar General of this court, comma, also by special messenger at the cost of the appellant to be deposited by June 13, 2025. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants, which have liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Next. So all applications are disposed of. Mr. Boral, whoever is appearing with you, please give the name.
Lordship, my learned senior, behalf of respondent number 11 and 12, is suffering from high fever, praying for not
Who?
this week.
Who is he?
Mr. Shubhodhi Pramanik.
Yes, what do you say? What is the application?
My lord, I'm on behalf of the appellant, my lord. This is an affidavit of service. My lord.
All have been served.
Yes, my lord. It has been served, but many of the services have come back, but they are appearing. She is appearing on those behalf.
I am appearing for 1, 2, 4, 5, 8, 9, 10. 8, 9.
Who are left out? 3,
5, 8, 9.
3, 6, and 7 are left out. You are appearing for?
11 and 12.
10 is also left out.
13, 14.
How many are there in total?
13, 14, 15 are there.
So what about them? 3, 6, 7, 10, 13 to 15? Have they been served?
Yes, my lord, we have served everyone, but some of the copies have come
You
back.
have not served everyone. You have sent
Yes,
on
yes,
sent to
sent,
everyone.
sent.
How
Yes.
many have been served? That is our question.
Yes.
Please ascertain from the affidavit of service whether these people have been served. 3, 6, 7, 10, 13 to 15. You can ascertain and come back tomorrow.
Yes, my lord. Deeply obliged, my lord.
affidavit of service একটাই দিয়েছেন। Very good. At the time of call, comma, learned counsel for the appellant seeks to file an affidavit of service. Push up, it is fairly submitted by learned counsel that some of the attempted services have returned with different endorsements in the track reports. Push up next para. Learned counsel for the respond numbers 1, 2, 4, 5, 8, and 9 on the one hand, and for respondent numbers 11 and 12 on the other, appear in court today, full-stop as such, further service on the said respondents is dispensed with, full-stop. However, learned counsel for the appellant is requested to apprise us as to which of the non-appearing respondents, being respondent numbers 3, 6, 7, 10, and 13, 7, 10, 13, 14, and 15, have not been served. Full-stop. Learned counsel shall also take instruction as to which of the said unserved respondents did not contest in the code below. Take both instructions, ma'am.
Yes,
Which of them have not been served,
Yes,
and
my
if not served, whether they contested in the code below. If
Yes,
they did
my
not contest, we can think about dispensation of service.
Yes, my lord.
For ascertaining the same, let the matter stand adjourned for the day. Come back tomorrow with
Yes, deeply obliged, my lord.
file your affidavit of service tomorrow. Because otherwise you cannot ascertain.
Eventual service has not been completed before the trial.
What is not complete, Mr.
11 and 12. But from the order.
But they are appearing, so no difficulty there. Among the non-appearing respondents who did not contest, that is what.
Deeply obliged, my lord.
Thank you. Effect আছে?
This kind of affair is not maintainable before there is a novel court. Deadlock killing আছে।
কাল থেকে করবো। চলে গেছে কলার। ঠিক আছে। That is maintainable কিনা জিজ্ঞেস করছি।
Number 17.
আপনাদের পিয়ন খুঁজতে বলেছেন 6 নম্বর চাবিটা কি করে আজ সকালে মিলিয়ে দেখেন হিয়ারিং তো আমাদেরই তো ঘর থেকে এই ঘর থেকে এখান থেকে এখানে আসতে হারিয়ে যাবে yes you are appearing, Mr.
This is my application for modification of the order.
Vakalatnama has been filed.
First of all, I should ascertain from my learned friend where he sits, so that in subsequent
13.
I can
room number 13.
serve him a
Room
notice.
number 13. Room number 13.
Room number 13.
Old criminal like me. Not so old. I mean.
This is my initially I after filing of this appeal, I filed an application for visitation. On 10th March, your lordship directed the respondents to produce the child on every Saturday at the South City Mall at 5 p.m. from 5 p.m. to 7 p.m. Now, on the first Saturday after 10th, she produced the child. Thereafter, on the next Saturday, she didn't turn up. And my lord, on the third Saturday, my lord, she came at 6:30. Thereafter, my lord, she didn't turn up on any days up to today. On the last Saturday, my lord, when my client, my lord, called him over phone, my lord, she says, "I shall see you in court." So, my lord, when the Can 1, my lord, the application for visitation came up for hearing, I sought for variation of the order. My lord, I prayed before your lordship that on last Friday of every month, let the child be handed over to me, and I shall return the child on Sunday at 5 p.m. Then your lordship, my lord, was of the opinion that since an variation is sought for, you should file an application. Can 2 is, my lord, for variation of the order.
Can 1 was disposed of?
No, my lord. Can 1 is also pending. My lord,
Can 1 and 2 we can take up together?
Yes, my lord. Yes, my lord.
Yes. Why shouldn't you grant that?
No, my lord, actually, the minor daughter is a my lord school-going girl.
Age?
And age, my lord.
Near about 8, my
lord.
lord. On August,
7,
she will be attaining 8.
And my lord, in DPS, my lord, Delhi Public School in Barashat. So, my lord, if your lordship, my lord, the venue of visitation kindly modified in that area, Sun Mall or anything, my lord, in the Modhamgram.
We directed where? South City Mall?
At South City Mall, because, my lord, the notice was received by the respondents at Mahestala.
You are deciding in
No, my lord, I am
Mahestala.
now
Only
residing, my
every
lord,
now and then
Barashat.
she is changing her residential
Barashat,
address.
because my lord, my school is going.
What is this? Don't keep it. Keep it with you. Keep it with you. What is this?
My lord, the school, my lord, school-going girl, and he is my lord.
No, you were served notice and your address still is at
Mahestala.
Michael Nagar. Yes. No, not Michael Nagar.
Mahestala, my
Presently, yes. Oh, presently, Mr. Rai, you have
My lord,
added presently.
my lord, that address she, my lord, furnished, but my lord, she is not residing there.
Now she's residing at
Now, my lord,
both
now where she
Gram
is,
and Michael Nagar both are in north.
not.
My lord,
Now,
that
my lord,
is-
where, I do not know where
is
now she
the
is
main
residing.
difficulties, my lord.
No, you have given the addresses.
But my lord, in both these addresses, those who are furnished by her, my lord, she is not residing there.
Oh.
Now, my lord, she is residing somewhere else now.
And I will, my lord, give the my lord, fresh address of the particulars.
Right now, because
Barashat.
he has to know the not your address, the child's address.
Barashat, my lord.
Barashat is a wide area.
My lord, Barashat, my lord.
Exact address, please.
My lord, I will.
Give it right now.
My lord, I take my lord instruction and I will, my lord, give.
We'll direct the entire custody to be given to him. If you go like this.
Any
Why
my
didn't
lord,
you produce the child on the second and the third Saturday and thereafter?
no, because when the long journey, that is the main thing. It's a Barashat to.
Why didn't you ask for a modification of our order? You are flouting the order of court, sir. You are in contempt of court. Just because of the long journey, you have flouted an order of the court without seeking any variation. Why didn't you ask for variation?
Because my lord, this Barashat to South City Mall, that is subject to your lordship's
Your
correction.
client will be present in court with the child. We will give the custody to him. We are keeping it immediately after the vacation. But in the meantime, we'll make arrangements for so that father gets custody during the entire vacation. Your client should suffer that. You cannot play with the court, sir.
No, no, my lord. Because the just my lord, sir, changed of brief, my lord, I have to, my lord, take instruction, all this thing.
We'll keep it tomorrow. Come with the address.
My lord, address I will, my lord, submit.
Come with the full address in writing.
My lord, my lord.
You'll have to hand over the writing to you, Lord. We'll keep it tomorrow.
My lord.
Sir, Rai, please come back.
My lord.
Can 1 of 2025 is an application for visitation rights filed by the appellant father in respect of a 8-year-old minor daughter.
Yes, my lord.
Minor daughter. Full stop. Next para. Can 2 of 2025, comma, on the other hand, comma, is for variation of the initial ad hoc arrangement of visitation made by this court. Full stop. Learned senior counsel appearing for the appellant submits that despite the specific order of this court that the child shall be produced on every Saturday. That was the first.
Every Saturday.
On every Saturday at a particular time and venue, comma, the child was not produced on the very second occasion, and on the third occasion was produced excessively late. Full stop. Thereafter, till date, comma, the child has not been produced at all. Full stop. Upon being asked, comma, learned counsel now appearing for the respondent appearing for the respondent submits that due to the long distance between the present residence of the respondent, who is residing somewhere in Barasat, the child could not be produced in time. Full stop. We, however, are unable to accept such flimsy explanation, since in such event, it was open to the respondent wife stroke mother to file an appropriate application for modification of our order. Full stop. It transpires that the respondent is deliberately violating the order of visitation passed by us in the teeth of the said order at her own sweet will. Full stop. However, before passing stringent orders in that regard, we direct the respondent to furnish her current address in detail in writing to the learned advocate for the appellant by tomorrow. Full stop. The matter shall next be listed tomorrow for passing appropriate orders.
Well, kindly this take is day after tomorrow.
No, tomorrow.
I'm with.
My lord, I am for the appellants. This is my affidavit of service. Out of 4, my lord, 1 and 4 has been served, and 2 and 3, my lord, no report is there.
What is the nature? Proper court fees and other defects have been removed.
Yes, yes. What, my lord?
No, let us just check up. Last. No, defects have not. Deficit court fees there.
They suit for partition.
Court fees have been ascertained at 90 rupees.
I have paid most probably 100.
We have paid 80, only 10 rupees. Put it today. And what is the application? And what is the appeal against Mr. Mahato?
My lord, the suit for partition and my lord, injunction has been decreed. Partition has been refused. My lord, the permanent injunction has been given. And my lord, I have challenged that.
You are the plaintiff.
I am the defendant.
Achha.
On the last occasion, my lord,
defendant has not filed any cross appeal because partition was no.
My lord, refusal, ground for refusal is, my lord, it is property granted by the government. Therefore, partition cannot be done.
But declaration of their title has been.
Well, so far the
title has been declared by the same logic that patta. Patta. Very good.
Well, my prayer for injunction regarding possession has not been given on the last occasion. Because my lord was of the view it should not be.
We are not sure as to who it was.
No, my lord, I have also produced the record of rights. They have also.
No, but there is a decree of court.
Yes, since the decree of court, my lord, expertise, my lord was of the view it should not be. But now I have.
2 and 3 have not been served. What can be done?
But 1 and 4 all have, my lord, the plaintiffs all are.
Oh, right.
They filed the suit together.
Right. Very good.
And
what injunction did you grant, Mr. Mahato?
My lord, directed regarding nature and character, and my lord, transfer, there was an email. So for possession, there was no.
Possession, it will be difficult at this stage without upsetting the findings.
My lord, the trial judge relied upon the original patta produced by the plaintiffs. My lord, the Rockland Land Officer appeared as a witness. My lord, he produced the records of the case, filed a report enclosing the patta granted in my favor. Well, those have not been taken into consideration. Those pattas are prior to the patta granted to the plaintiff.
Those were exhibited?
No, well, it was produced by the BLRO.
Unless those are on record, those
report has been, my lord, exhibited. Therefore, all the enclosures are also exhibited. But the learned judge has not taken into consideration those. My lord, I have branch of the copy My lord, where my lord will find that the patta was in my favor in
Mr.
1973.
Mahato, granting possession at this stage would be
But
allowing the
otherwise,
appeal.
my lord, they are creating difficulties. My lord, we are in possession. My lord, record of rights is also in my favor. I have annexed the record of rights in the.
No, we are restraining them from creating third party interests. What difficulty will
My
it
lord,
be?
they will evict me. They will force me out. My lord, they ousted me. My lord, I have
The due
annexed
process of law they
my
can.
record of rights in my favor. My lord, kindly see page 9 of the application. Even after my lord passing of this order, they, my lord, tried to evict me with the help of the police. They made complaint before the police.
But how then they must have also produced a patta.
Yes, they have produced the patta. That is prior, after the my patta. The patta in my favor has been granted in 1973, 69 and
You
73.
have to
Two
go into
pattas
that
are
question
there.
whether fresh patta could be granted. But as of date, the trial court has found that the last patta is in there.
No, last patta is not mentioned. But the learned judge has.
We are asking you. You are saying that. You are saying that their patta is subsequent to yours.
Yes, yes.
So the last patta is in their favor.
Yes, but
Court
therefore
has
the
relied on
total-
that and held
total
their
land-
possession.
No, my lord, total land is lesser than the patta granted in different persons.
Yes.
That is the difficulty. But the
Sure.
first patta which has been granted to my client, well, that should be treated into that will
That
required to
will
be
decide
taken
in
into
the appeal.
consideration.
That will decide in the appeal.
Well, kindly visualize, they are not appearing today, even after service.
In the appeal also, if they don't appear, then we'll hear it expert and pass judgment and degree.
Yes, but my lord,
But
so far
at the
possession
injunction
is
stage,
concerned.
that will be allowing the appeal before
Well,
hearing.
kindly visualize, my lord, record of rights in my favor. Well, record of rights is presumption of
Subsequent patta in their favor.
well, subsequent patta. My lord, kindly consider the total
We
area.
don't know what happened in between. I mean, we don't.
Well, my patta has not been cancelled. The block land ransom.
Yes, that we can consider in the appeal. That will be hearing the appeal. It will be a mini trial of the appeal. If they have not disposed it to you during pendency of the entire suit, they won't dispose it to you in
They have tried last week, my lord. They tried for that. But kindly visualize this situation. But the record of rights is the last record of rights, my lord. Kindly consider. It cannot be, my lord, overlooked.
Let us see the finding of the trial court, Mr. Matra.
Page 3, decision with reasons. All the issues.
Yes.
All the 5 issues are taken up together for the sake of convenience and brevity. The effective date of vesting under the West Bengal Lands on 15/2/1971 and the effective date of transfer under the West Bengal Lands on 1969. Admittedly, different number 7 and has 25 decimals. Different number 8 has 1 acre 50 decimals. Predecessor of different number 9 to 12 have 1.50. Different number 13 has 50 decimals. It has been submitted by the runner for the plaintiff that noting the date of vesting, that is 1971, under the West Bengal Land Forms Act, taking into consideration of the family member of the original riot and on consideration of transfer of land by the big riot on 7th August 1969 and after such transfer land on 7th of August 1969. Land would be taken into consideration under the head of the big riot and in view of vesting proceeding under section 14(t)(3) of the West Bengal Land Forms Act, patta in respect of vested land would be granted to the landless persons under section 49 of the Land Forms Act by observing rule 202 and 203 of the West Bengal rules.
They have title about 75 decimals of land. It's a larger land.
Yes.
So their right has been restricted to that 75 decimal where they've been granted patta. You have right, still have right or position maybe regarding the other portion.
My lord, the difficulty is, my lord, the total area has been given patta. But if they have given 75 decimals, it will exceed. Therefore,
Cannot ascertain that at this stage, at the injunction stage.
but my lord, kindly consider, so far the patta granted in my favor, that is prior. Therefore, I am entitled to get my possession in respect of my property.
But last patta indicates the current position of them. Might have been granted legally. We may hold it, set it aside in the appeal.
Last patta has been given, and for that reason, my lord, total area has been exceeded. For that reason, my lord, they will suffer.
They will
Suppose
suffer
two deeds, suppose two
if you allow
deeds.
the appeal.
Well, suppose 2 deeds. The first deed will be, my lord, first deed shall be the effective. The second deed, if it is, my lord, found that the area is exceeded, how he will be entitled to get the possession? And my record of rights in my
Your
name.
patta, we do not know whether your patta covers the entire 75 days. That will require a fine. That will require an assessment of the evidence. How far your patta is
Well, it
goes
is,
into that 75.
well, total area. Well, kindly come back. I shall.
Yes, Samarth.
Now it is their plain case that the total area of the plot is, my lord, 4.97 acres.
We annex the plaint.
My lord, this is page 3, my lord, paragraph 3, last 3-4 lines. My lord, they have got the patta of 75 decimals of land.
Yes.
In settlement case number 111/80/81 on 10th of April 1981, where, my lord, our patta has been granted in year 1976 and 79. Therefore, my respectful submission.
Where is your written statement?
My written statement.
Where have you stated that?
Yes, I have.
But we cannot ascertain, Mr. Mahato, the exact. We have to compare those side by side and see whether even 94 decimals tally with their 75, because in a synopsis you have stated 94 decimals.
My lord, they have paid for partition.
Partition has been refused rightly.
Yes. My lord, why they have paid for partition? They are not getting the possession of 75 decimals of land. So many persons are there in plot number 705/893. Since they are the, my lord, subsequent patta holders.
And by claiming partition, they have admitted at least that it was a joint property.
Yes.
So then the exclusive portion, we cannot attribute exclusive portion to you also regarding that 75 specifically.
My lord, their patta
Because
is.
if it's a joint portion, as you say, there is no partition.
Yes.
So pattas have been given to many people.
Yes.
So we cannot fix your position
But
to
so far
grant
the
possession.
first patta is concerned, the prior pattas are concerned, they have got the possession.
That is also in respect of a particular portion which is not demarcated. Maybe.
Yes.
If that
But
be so, we
same
cannot grant you possession, restraining the others from disturbing your possession.
Well,
we have to ascertain then which portion was given to you, which portion to them. Nothing is on record.
court has said, my lord, since it is
Court
patta.
may have erroneously said.
Yes.
But Mr. Mahato, for grant
It is
of
a joint
injunction,
property.
we have to enter into that exercise of comparing the pattas, which is not done at the injunction stage.
That's true. But my possession, my lord, the trial court has secured their possession. If it is a joint property, my lord, the other persons who are the co-sharers.
Yes.
In that sense, my lord, their possession is required to be, my lord, secured. My lord, kindly consider it is not the ancestral property. It is patta has been granted. Suppose some persons have purchased property.
No injunction has been given.
Well,
no injunction has been given.
No, in that sense,
barely been declared that they have title interest possession regarding 75 days.
Possession.
So there is no injunction against you also.
Well,
declared their possession, but
possession,
granted no protection to that.
Declared. Possession has been declared.
Yes, we cannot upset that at this stage.
Well, my possession is also valid, is required to be secure. Well, their possession has
the
been
present
secure.
appeal has been preferred against.
Kindly visualize.
So, Mr. Pahathu, we have heard.
This thing.
No, we have heard.
Consider their patta is subsequent patta.
The present appeal has been preferred against a decree whereby the rights of the plaintiffs stroke respond numbers 1 to 4 as well as their title, interest and possession over 75 decimals of land has been declared. Push up next para. Learned counsel appearing for the appellant submits that the learned trial judge, while passing the impugned judgment and decree, completely overlooked the records produced by the appropriate authority, which was also marked as an exhibit. Push up from the said exhibits, it would be evident that prior pattas were given in favor of the defendant number 1 stroke appellant than that of the plaintiffs. Push up next para, that apart, the records of rights also indicate that the property in question has been recorded in the name of the defendants. Full stop. As such, it is submitted that injunction be granted restraining the plaintiffs stroke respondents 1 to 4 from creating any third party interest and or from disturbing the position of the defendant number 1 stroke appellant. Full stop. Next para. We find a strong prima facie case having been made out by the appellant inasmuch as the learned trial judge proceeded to grant the decree in favor of the plaintiffs only on the premise of the patta produced by the plaintiff by generally discussing the nature of rights created in favor of patta holders without however adverting to the relevant material documents on record which go on to show that prior pattas were granted in favor of the defendants. Full stop. Next para. As such, we are of the opinion that the subject property should be protected from creation of third party interest in any manner. Full stop. And or from being changed in character. Full stop. However, a dichotomy arises in respect of whether an injunction restraining the plaintiffs to respondents from disturbing the appellant's position ought to be granted at this stage. For sub next para, even if we go by the arguments of learned counsel for the appellant, the creation of prior pattas in favor of the defendant number 1 stroke appellant might have created strong rights in favor of the appellant, which could not have been displaced by the subsequent patta granted in favor of the plaintiff stroke respond numbers 1 to 4. Full stop. Next para. Also, the extracts of the records of rights show that the plaintiffs are that the defendant number 1 is in possession of the property. Full stop. Next para. Even if that be so, we find that the respective extents of the pattas granted to the plaintiffs and the defendant number 1 ought to be explored before coming to any positive finding as to possession. Full stop. Apart from the fact that the land in question, in respect of parcels of which pattas were granted in favor of the defendant parties, being a larger piece of land, we also find that without a comparison and perusal of the respective pattas granted in favor of the plaintiffs and the present defendant stroke appellant, it is not possible to come to any finding as to what is the exact extent of possession of the parties respectively, and as to whether there is any intersection between the property lands granted in favor of the plaintiffs on the one hand and the defendant number 1 on the other. For sub next para, also the property, the larger land has not been well demarcated, which creates further difficulty in holding at this interlocutory stage that the defendant number 1 stroke appellant is in exclusive possession of any particular portion of the property. Push up next para, we find that the plaintiffs also prayed for partition, thereby admitting that the property is joint in nature. Push up thus, the nature of possession, even as per the plaintiff was joint. Push up next para, it would be a risky proposition, contrary to settled law, to hold a mini trial at this stage and enter into a material appreciation of the entire evidence on record while deciding an injunction application in connection with an appeal to specifically ascertain the exact extent of possession of the parties and as to whether they are at all in exclusive possession any portion of the property. Sub next para, thus, despite a prima facie case having been made out by the appellant, the appellant has failed to convince us that at this stage, we should enter into a fact-finding exercise by examining the entire documents on record, including the pattas granted in favor of the defendant number 1 stroke appellant as well as the plaintiffs, and to come to a conclusive finding as to whether the appellant is actually in exclusive possession of any particular portion of the larger land. Full stop. Hence, we are not inclined to grant any injunction at the present stage. Full stop. Next para. Contrary to the arguments of the appellant, although the possession of the plaintiff stroke respondent numbers 1 to 4 in respect of the suit plot has been declared, no permanent injunction has been granted to protect such possession. As such, the possession, if any of the appellant has not been ex facie jeopardized by the impugned decree, so much so as to seek a protection of such possession. Full stop. Next para. In such view of the matter, we are not inclined to grant the injunction in respect of possession as sought by the appellants. Full stop. However, in view of our above discussion, can 1 of 2025 is partially allowed, thereby restraining the plaintiffs stroke respond numbers 1 to 4 and or their men and agents from selling, transferring, alienating and or encumbering the suit property or any portion thereof in favor of any third party, or changing the nature and character of the suit property in any manner, both till disposal of the present appeal. Push up, the appellant shall put in due requisites for service of notice of the appeal on the plaintiff stroke respondent numbers 1 to 4 within June 13, 2025. Push up, the trial, the service of notice on the other respondents is dispensed with for the present. Push up. Next para. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within June 13, 2025. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants, who's of liberty to the parties to mention the appeal for hearing as and when the same is so ready. প্রথমে একটা affidavit of service file to be kept on. Mr. Mahato, please take back your plaint. You have not referred to it directly. এটা পেয়েছেন, থানা যেতে হচ্ছে না তাহলে। Yes.
Lordship, I'm for the OP number 1, Lordship. Lordship, I have served the copy.
Only 2 respondents in the appeal?
Yes, Lordship.
Well, yes, what is the matter?
Lordship, I have just received my instruction from my client, Lordship, today, Lordship.
Your client's fault. No, he should have given you earlier.
My Lord, I'm late.
You are enjoying an injunction. You are already.
My Lord, I'm late.
So you fight out. So on their prayer, will grant the adjournment.
My Lord, kindly appreciate.
My Lord,
the appellant is
I'm
the
praying.
agreement for sale holder.
Let her move her application first. Yes.
My Lord, Ashish Chandra Bagchi is leading in this case. My Lord, I'm praying for not this week.
You are the worst sufferer.
I'm the worst sufferer. I'm the bank. I have.
You are the bank.
I'm the bank. I have.
How are you suffering? What is the injunction granted?
Kindly seize the order dated May 6, 2025.
Oh, that RPC action has been initiated.
Yes, and they have
kindly
this
keep
point
this
that
of
on
the
the basis
package,
of
my Lord.
unregistered agreement for sale, I cannot enforce my statutory. So I am the worst sufferer.
My Lord,
Even
kindly
in
keep.
case of unregistered agreement for how can
Have you filed your opposition? We directed you.
the public after receiving your
File your opposition will come back after the vacation. They're asking for time. Adjournment is sought on behalf of the appellant as well as the respondent number 1. Full learned counsel for the respondent number 2 bank submits that the bank is a worst sufferer, since an injunction has been granted on the strength of an unregistered agreement, unregistered purported agreement. Next para, be that as it may, in order to enable the parties to bring on record the relevant pleadings and materials, the respondents are directed to file their affidavits in opposition within June 13, 2025. Proof of reply, if any, shall be filed by June 20, 2025. The application shall be listed next for hearing on June 23, 2025.
Grateful, Lordship.
Please give your appearances, all of you. Yes. দুজন জোরাজুরি করে গেল পুরো কল রিসিভ মেঘনা দাগ একটা এফিডেভিট অফ সার্ভিসটা লিখে নেবেন ইয়েস
I'm appearing for the appellant, my lord.
রাইট
My lord, this is the first day, my lord.
First.
And we have filed two CAN applications.
You have given only the name of the appellants, not the respondents.
My lord, this is for grant of letters of administration being
Ah.
appealed by the order, and this order was passed ex parte.
There is no other error. There was no citation.
We have done citations. There was newspaper publications. Everything was done.
So they have to be implemented here also.
My lord, we have already put their names in the pleadings, my lord.
We have challenged what
The final order and judgment, my lord. My lord will kindly see. This is
So your letters of administration was refused.
for want of will. My
No.
lord will kindly come to page 32 of the
You sought for letters of administration on the strength of a will.
No. My lord, we do not have a. The learned district delegate, they dismissed our application that letters of administration cannot be granted to us because there is no will. My lord will kindly come to page number 32 of my section 5 application, my lord. There's a delay of 53 days, my lord.
Then you have to serve and come back. Somebody, you have to serve somebody. Who?
My lord, this is an ex parte order. If
The
my
heirs
lord
of the other heirs have to be served.
My lord, there are the three, the daughter-in-law, the two grandsons
You are the only
of the
heirs.
deceased
Yes.
are parties. My lord, I think there is, my lord, inadvertently a short cause title have been made, Nivedita Singh and others appellants. But what we see from the appeal, my lord, all the three appellants have been named. So if my lord will kindly grant me
No,
leave, I'll
appellants
make-
have been named. There is no respondent. These are the only, you are the only heirs.
They are the daughter-in-law and the grandsons, and there are two daughters of the deceased, my lord.
Then
Who were residing, we have also made them a party. They do not want to become the appellants, my lord.
then they have to be made respondents.
That is what they were. We had made all the summons. It was a summon proceeding. Summons were served. Thereafter, newspaper publication was made, my lord, but they did refuse to appear before the lower court below. Now, if my lord will direct me, I will make them a party, my lord. I do not have a problem. We had served summons upon them, my lord. The bailiff had also
No,
gone.
they
Summons was
definitely
served.
have to be implemented. We find from the memorandum of appeal and the connected applications that the other heirs of the deceased, in respect of whose property letters of administrations were sought by the appellants and refused by the district delegate, have not been implemented. Pushed up. Accordingly, the appellants are directed to implement the left out heirs of the original
The
owner
two daughters.
of the property. Puts up necessary consequential amendment to the cause title of the memorandum as well as the connected applications shall be carried out. Can you do it today or by tomorrow?
2 days time, my lord.
Carried out, shall be carried out by May 23, 2025. Pushed up. The appellants shall serve copies of the memorandum and all the connected applications on the added respondents, indicating that the applications shall be listed for hearing on June 16, 2025, when an affidavit of service to that effect shall be filed.
My lord.
If you can convince us on good service, we may consider expediting the appeal. This is a very short appeal, so
Very, very short appeal.
very short appeal.
So, my lord, the normal process of service will suffice.
Yes, you'll serve by reset post. Yes,
I will.
and file track reports, affidavit of
Yeah, I
service.
will, my lord.
Usual.
I'll file my affidavit of service.
This is not regarding the service of the appeal. This is regarding the application.
Yes, my lord.
You
I will-
can only hope that they appear through somebody so that we can dispense with.
My lord, we had convinced them by all kind of service. All mode of services were done. We have also attached the paper publication in the appeal, my lord, as well.
They're not appearing.
No, my lord. My lord, this is a 2017 case, my lord.
আচ্ছা,
And there had been innumerable services, my
একটা
lord.
লাইন অ্যাড করে নিতে। In view of the very যা বললাম তারপর in view of the very short conspectus of the appeal, the service of notice regarding the The service of notice by the appellants as directed above shall be construed to be good service in respect of the notice of appeal as well, full stop. It is made clear that the appeal itself shall be taken up for hearing along with the applications on the returnable date, comma, subject to good service having been effected.
Much
It
obliged.
will appear under the hearing application, but understanding is that we will take it up.
Yes,
But if you cannot serve, then we cannot do that. Then we'll have to direct paper publication and
we'll do it by this week, my lord. Much obliged.
I appear for the appellant. I'm led by Mr. Mukherjee, my lord. He is there on the virtual.
For the respondent, Mr. Mukherjee. Yes. Yes.
Mr. Joy Shah had given me a call then.
I had called, not Joy Shah. I had called Mr. Mukherjee.
Mr. Josh's elder brother has called you.
I'm sorry, I made a mistake.
Yes.
My lord, we have not been able to, my lord, reach a settlement. My lord, your lordship had started hearing the appeal on merits. Well, I don't mind if the appeal is heard on merits, but my lord, Mr. Mukherjee has said that, my lord, we should try and settle. And my lord,
keep it after the vacation, immediately after the vacation. When is convenient to all of you, Mr. Mukherjee and Mr.
well, lord, one of us will have
Your
to go.
lordship will be happy to get rid of this matter. It's so complicated.
That is sufficient warning, Mr. Mukherjee. Thank you for that.
No, well, I'm telling you.
No, warning in a good sense. I mean, you're making us
Well, a very short matter in any way.
Yes, we know the meaning of very short. When should you know? That will be risky for you.
Whenever.
1 week after vacation, we are keeping it. Then June, we are reopening on June 9th. So we are keeping it on 16th June.
Yes.
Monday after the first. 16th June, Mr. Mukherjee?
Except 16th any day.
17th June then. Very well. What will be the reason, Mr. Mukherjee, for the adjournment on your prayer?
Make your lordship's pardon, my lord.
What should be the reason for us adjourning it today? We should have some pretext. We have to state that in our order. Your prayer for adjournment or what?
I am always in favor of adjournment.
Chance of settlement. Chance of settlement is there. Very well. It transpires that there is a possibility of amicable resolution of the dispute between the parties, full stop, to enable the parties to explore such avenue, comma, let the matter stand adjourned till June 16, 2025, June 17, 2025, full stop. In the event no settlement is reached in the meantime, comma, the matter shall be taken up for adjudication on the returnable date. Thank you. Thank you. ছুটির আগে ওদেরও ইচ্ছে নেই আমাদের ইচ্ছে
On behalf of the appellant, my lord. So it is, I filed a section 5 application and this stay application is also there, but it is not appearing, my lord.
What is not appearing?
Well, section 5 and this stay application, my lord. It is defective for.
Can 1 and 2 both are appearing? Yes. Item 24. Shravanti Das.
Yes, my lord, it is written defective.
Defective out of time. That's why you filed a section 5.
Yes, my lord. My lord, this is my lord.
No, defective, the mark, till the marking is there in the memorandum, it will be marked as defective in our list. What is that you have served on the other side? Is appeared for the first?
No.
We'll direct you to serve both the applications together. Serve and come back. The appellant.
And section 5.
Yes. The appellant shall serve copies of Can 1 of 2025 as well as Can 2 of 2025 on the respondent, indicating that the applications shall be listed for hearing on June 16, 2025, when an affidavit of service to that effect shall be filed by the appellant. 16th June, please come back. We'll take up the.
My lord, I am for the respondent number 1 and 2.
Yes. Is she with you? The lady is with you?
Yes, my lord.
Very well. Yes.
Respondent number 3.
3. 1, 2, Mr. Hussain. 3, yes. Yes, Mr. Bhattacharya, what is the matter?
Lord, this is my lord. Kindly see your lordship's last order
my lord, I filed a suit for partition. Now, my lord, in such a suit, my lord, I filed an application under Order 39, Rule 1.
Take the microphone, Mr.
Order 39, Rule 1 and 2, my lord. My prayer for ad interim injunction was refused. My lord, challenging that, my lord, we have come up before your lordship. Now, my lord, my learned my lords have, my lord, passed an ex parte ad interim order of injunction, my lord, in my CAN application. Now, my lordship directed me to serve, and my lord, this is an
All are there are three only.
This is not a partition suit, my lord. This is not a partition suit. And my lord, summon has not been served till date, my lord, of the suit, my lord.
Yes, suit for partition.
No, this is not partition suit. Kindly see the prayers. Kindly see the prayers.
We recorded in our suit for partition. It isn't a suit for partition.
Yes, kindly see,
Kindly look at the
a preliminary decree of partition declaring the share of the plaintiff and each of the defendant, a final decree of partition making allotment or by appointment of partition commissioner.
My lord, look at the plaint once, my lord. Look at the plaint once, my lord.
If there is an, I wasn't told that
There was an expert injunction.
Yes, plaint is, my lord,
That is
appearing
subsisting.
page 16.
This is ad interim.
Subsisting.
My lord, let them go back before the trial court. Let them find objection and let the injunction be heard of.
It is something else, my lord. There's something else happening.
5 minutes, and I don't think this. I was not.
Your 5 minutes or our 5 minutes?
Either.
Then it will be longer. No, we'll definitely. We don't want to. It's his prayer. We have not granted that.
There is an expert.
There is. They moved the matter on 30th of April. Only then we directed service of
Lord,
copy.
I will show only 3 documents, my lord.
Nothing was shown.
You get an injunction order against them, you have not.
Yes. They বলে দিয়েছিলাম তো।
Lord, I will.
Affidavit of service you have filed.
Yes. চিঠিতে লিখে দিয়েছিল তো। Very good. May I once check the affidavit of service?
That the matter has been admitted and it's been fixed on 19th.
They have written in the letter annexed to this affidavit of service says we have admitted the appeal and direct the appellant to serve copies of application.
The injunction.
So they've given the date and you could have checked up from the internet. Why are you so surprised? When you get a copy, definitely you immediately check with the number, you check up on the website immediately. We do that as judges to see whether you are suppressing any other order. Anyway, so
My lord, kindly consider the prayer.
no. First, let them move it.
Yes. Kindly see the memorandum of appeal. My lord, what was the order? My lord,
Let
why
us see
your
the interim
lordship, my lord, had passed the interim
Why?
order?
Yes, let us see.
Kindly see, my lord, the fourth paragraph, the plaintiff's case in short is that the plaintiff is the owner of the suit property by way of registered deed of will and by registered deed of sale. It is alleged by the plaintiff that the defendants are claiming to be the alleged co-sharers in the suit property by procuring purported deeds and the deeds and documents executed by defendants which have no legal existence in the eye of law, and therefore the documents executed by the therefore the plaintiff filed RTI appeals before the different authorities. On the other hand, the plaintiff submits that he has reason to believe that the deeds by which the defendants are claiming their right over the suit has the property are illegal and void. However, the plaintiff's application for rectification of record of right has not yet been conclusively decided. Due to the said illegal and forcible acts of the defendant, the plaintiff, the co-owner, may be deprived from enjoying her peaceful possession.
Their deeds cover the entire property.
Their deeds cover, my lord, the entire property.
You have challenged those deeds also.
Yes, my lord. My lord, what happened, my lord? This is, my lord, very, my lord, cumbersome, my lord, situation. Now, my lord, our name was recorded. My lord, may I, my lord, continue with the order?
No, we are doing both together. We are hearing you and reading the order.
Then, my lord, kindly see, my lord, the next line, my lord. However, the plaintiff's application for rectification of the record of right has not yet been conclusively decided. Due to the said illegal and forcible acts of the defendant, the plaintiff co-owner may be deprived from enjoying her peaceful possession of the undivided suit property, and as such, the defendants should immediately be stopped and restrained by an order of injunction. Otherwise, the plaintiff shall suffer immense loss and injury. Then, in support of these plaintiff's case, my lord, following documents were relied upon. Then, my Miller, kindly see the next paragraph. Having heard the learned advocate for the plaintiff and on perusal of material on record, including the documents relied upon on its behalf, it is prima facie appears to the court that the plaintiff has only a reason to believe that the title of the defendant is not correct. According to the plaintiff's case, record of right is also not correct. Such a dispute cannot be decided at this ad interim stage without hearing the other side. The balance of convenience and inconvenience is not tilted in favor of the plaintiff. Hence, my lord, my injunction was rejected.
Records are right are in their name.
Record, it was in my lord, in arrest record, it was also in our name. LR was also our name. My lord, it gone. We approached before the my lord concerned Lock London land.
No, LR record was also in your name. That was rectified in their favor.
That was rectified according to their own deed. Now, my lord, it completely, my lord, therefore we filed miscase before.
What is your challenge before the deed? Against the deeds, their deeds.
My my lord, land, my lord, my portion, my lord, it cannot evaporate.
Their deeds are subsequent to yours.
No, what happened, my lord? This property belonged to one Taroknath Mukherjee. Now, my lord, that his name was recorded in the arrest record of right. Now, my lord, after the my lord arrest record, my lord, it was continuing. The all of a sudden, my lord, in LR, it was also recorded in our name. Now, my lord, Taroknath Mukhopadhyay. Now, my lord, all of a sudden, that was, my lord, that is gone. We filed, my lord.
Gone means?
My lord, deleted from the LR records.
Somebody else's name must have come.
Yes.
Their names.
Their names. And my lord, and also the name of Howrah Jila Porishad, because they say, my lord, a portion has been, my lord, from direct purchase policy, my lord, they have, the Howrah Jila Porishad has purchased. Now, my lord, my lord,
what about this probated will and all?
Probated will is Taroknath Mukherjee's will.
Taroknath Mukherjee got it by that will?
No, he, my lord,
gave the
property to the, my lord, daughter-in-law.
You purchased from daughter-in-law?
No, we are the, my lord, daughter-in-law. Yes, yes.
You are the daughter-in-law?
Yeah, Lekha Chaudhuri, his mother's, my lord, his daughter's, my lord, Taroknath Mukherjee's daughter's.
He bequeathed the property to you?
Exactly. My mother.
Your mother?
Mother.
And you have obtained a probate of that?
Exactly.
So what is your challenge to the deeds?
Non-recording of my lord name, my lord, does not mean my title to the property is established.
No, if they have title to the property, who executed the deeds in their favor? Taroknath Chaudhuri?
Santosh Dhar, my lord, if your lordship.
Who are they? Santosh Dhar? They're related to you?
Yes. Kindly comes to page 60 of the my lord application.
$60 is a record of right. What is your case in the plaint?
Yes. My lord would kind enough to come to my lord page 17. It starts from my lord 16. Kindly comes to my lord.
We have not challenged the deeds.
Nothing, your lordship.
No,
Just have a
no,
look at
I've
paragraph 3, paragraph 4 of the plaint.
Yes, I've my lord challenged, my lord. I don't claim it, my lord, in its entirety, but partition.
You say their deeds cover the entire property.
No. I have partition, partition, my lord, to my extent only.
They have purchased undemarcated portions.
My lord, kindly see, my lord, deed, my lord, their deed.
What is your plaint case? First, let us see that.
Very well. Kindly comes to,
You have to
my
take out
lord, page 18, my lord, para 4.
Taroknath will probate such and such residual legacy. Yes, 4. Claiming to purchase portion of the share also. Very good. From alleged co-sharer by strenuous efforts, such and such. So you admit that their purchases you are virtually admitted.
But because I cannot claim the entirety of that suit property, my lord, my portion. Then, my lord,
they have purchased the other shares
from Dhar.
Who is Dhar?
Dhar, my lord, that's what I was showing, my lord, page 60, my lord, that's.
No, don't show us Dhar. I mean, tell us who is Dhar.
No, my lord, what happened, my lord? This Taroknath Mukherjee, my lord, he, my lord, gave a kabuloti in favor of this Dhar in respect of the suit property.
Kabuloti, does it confer a title? It was registered. Kobuliyat is not in the nature of a transfer unless it's registered.
Milord, it is recorded in the record of rights, Milord, as the Kobuloti Mule Dohol. Kobuloti Mule Dohol.
What injunction you have asked for?
Milord, finally comes to Milord the
Third party interest.
Yes, third
nature
party.
character.
Aste.
No, then you are the owner of a portion by inheritance.
Yeah.
And through the will
Will,
actually.
will.
Not by inheritance. Tested. So anything else, Mr. Bhattacharya?
This is at this moment, Milord, and if your lordship wanted to,
This is the only moment you have.
kindly see, Milord, their deed,
Yes.
which is the Milord.
Yes, their deeds you are showing something not demarcated or something like.
এটা হচ্ছে দেখাচ্ছ
Show us one of the schedules of their
page 98. Milord, this was Milord. Kindly comes to Milord. Page 10.
What was this refusal of injunction? 96? Same suit?
Yes, Milord, same order.
Same order. Achha, achha.
That is
Oh,
the
achha,
order
that
under
is-
challenge.
Yeah, right. Yes, page 98, one of
Yes.
the deeds.
Kindly see, Milord, the suit property is Elad Dag number 311.
Where do you find that?
Milord, kindly comes to Milord, page 108. What they have got, there is a chart, Milord, kindly see. Last one, 143 by 251 RS in LR 3670 decimal.
The entire land is butted and bounded. So within that, a particular portion.
And kindly comes to Milord.
All right. It has been, no, but map is there, orange, blue, yellow.
But kindly see again, Milord.
If there's map, it should be specific.
109 again, Milord, kindly see the third schedule of 109.
No, first let us see the map. Maps are not there.
Yes, Milord, 112.
আচ্ছা আচ্ছা
অরিজিনালটা আছে বড্ড
এটা তো খুব ডিমার্কেটেড কিনা বলা সুন্দরই তো এটা Yes, 149 or something you're saying? Some other page?
Yes, Milord, kindly see, Milord, they have, Milord, virtually said, Milord, I'm showing to her.
ডিটের মধ্যে কথা বলেছে ডিমার্কেটেড কিনা কিছু
South 7
Yes.
वो तो टोटल नीचे होता है 56 नीचे तो ये नहीं तो शेयर होता है
It has expert. Milord, the in 311, the total, Milord, area of Milord Dag number 311 is Milord 0.790 Milord decimals acres.
Which page?
Milord, if your lordship would kind enough to, Milord, if it was impossible to.
If it's not annexed here.
Annexed, Milord, due to its condition, Milord.
What is this?
Milord, the LR record.
Illegal records, forget. Let us see their deeds, whether it was demarcated portions. This page 167 is also similar. That is an agreement.
No, if your lordship would kind enough to see 102 last paragraph. whereas the purchaser Howrah Jela Parishad intended to purchase Rayat interest land out of total land measuring about 4.68 decimal in Elad Dag number 305-3345 decimal in Elad Dag number 307-1223 decimal in Elad Dag number 306 and 3670 decimal in 311 totaling 87.06
Howrah
decimal.
Jila Parishad is also an
Party. Therefore, Milord, they have purchased Milord, non-recording of my name, Milord, it was there.
Court says that trial court says that you have reason to believe that the title of the defendants is not correct. Have you stated that? We don't find any challenge to that title.
No,
You only have stated that purportedly or something like that was used. They claim to have title and all these things.
So, will kindly see, Milord, paragraph 4.
Record of right records their name exclusively.
Exclusively. Totally, Milord, out now we are. That correction of record of rights application is pending before the concerned land authority. Now, Milord, if your lordship would kind enough to see, Milord, page 18, paragraph 4, Milord, the plaint, the relevant portion is at page 19. But this is perhaps, Milord, statement made on the middle. The line starts with the word the purported deeds. The first, the purported deeds and documents executed by person or persons without having any lawful authority have no legal existence in the eye of law. Milord, this is perhaps what the learned trial judge was referring to.
But you have not challenged their title, their deeds.
Partition, Milord, I need not in its entirety.
No, we are saying that you have not challenged his title.
No.
Alternatively,
no,
yes.
Alternatively, yes. Alternatively, yes. Alternatively, yes.
The title to land acquisition and notification page.
Suit property is the entire thing.
No, I cannot.
Obviously, the entire property.
42 eastern portion.
But you claim to be the owner of a portion only.
Owner of portion, yes. Of
how can you make this alternative prayer even?
Not alternative. My main prayer would be, Milord, for partition.
The non-main prayer is that
why-
maintainable? The non-main prayer.
That's why, Milord.
Anyway, let us hear them.
Only one thing, Milord. If your lordship would.
Page 58.
Yes, kindly comes to, Milord, page 58.
Land acquisition interest.
Milord, this is a notice, Milord, under section 4 of the, Milord, Land Acquisition Act. Self property, Milord, the state initiated a LA case. Page 58. 58. But kindly see the note, the in caps, Milord, notice is kindly see to whom it was, Milord, the given.
The general notice.
Notice to interested person. This was issued to, Milord, my client.
The public notice.
No.
Like this was
property.
Kindly see, Milord, at the, Milord, bottom in Bengali number copy forwarded to at page 58. It's very illegible. But after under Act 1 of 1894, at the bottom, collector, then Act 1 under Act 1 of 1894. Bottom. Then, Milord, kindly see copy forwarded for information action to Taraknath Mukhopadhyay.
That's not legible in our code. Not at all there.
May I had it?
ওইটার মধ্যে শেডটার মধ্যে yes
in Bengali, Taraknath Mukhopadhyay. Therefore, Milord, although, Milord, this was, Milord, abandoned. This they never proceeded with this. But Milord, it shows that we had some, Milord,
right
possible of title to the extent.
Here the letter said yes, Mr. Banerjee. Or you, whoever. Just you are for the Howrah Jila Parishad. You are for Howrah.
No.
I'm for
Yesterday
opposite
they
party
appeared.
number 3.
Yesterday this matter was called on. They
You are for
appeared.
3. You are for 1 and 2.
One and two.
You said there are 3 different respondents only.
No, 4. My lord, my learned senior friend is perhaps representing Benias.
No, I'm representing
Overseas
overseas
found.
Benias him. I'm
Four,
foundries
four,
me.
Howrah Jilla Parishad is 4. We have sub. We have
Very
checked.
good. You are for this overseas iron.
Yes,
only.
yes.
Yes.
Kindly have a look at the plaint, my lord. Plus you will find it at page 16. But paragraph 2. So this recorded land subject suit property is 79 decibels, which is approximately 11.9 kattas. Paragraph 2 belong to Taraknath Mukhopadhyay, admitted position. It is pertinent, paragraph 3, pertinent to mention that Taraknath Mukhopadhyay during his lifetime executed a registered will which was probate and so and so before the district judge at Hooghly, and probate certificate was issued on 12/11/1962. Please mark this, Milord. Although there was no specific mention of the suit plot in the said will, but as per clause 9, the residuary legatee, Amiya Devi, became the owner of the suit plot. Again said Amiya Devi, during her lifetime, executed a registered will. As per clause 4, the said will, the plaintiff is entitled to the property as sole beneficiary. So property is not mentioned. Taraknath Mukhopadhyay gives, so it becomes residuary legatee. Whatever is remaining goes to Amiya Devi. Amiya Devi again probate to this person. Now, 4 your lordship has seen. 4 and 5 your lordship will just allow me to place. The defendants are claiming to have purchased portions of the share of the suit property from an alleged co-sharer. This they have naturally not disclosed. By strenuous effort, the plaintiff has been able to find out or search out few documents while the others are still not available. The plaintiff, in connection with the petition filed by the defendant number 1 and 2, WP so-and-so, came to know about the fact that one Santosh Kumar Dhor transferred 2 decimals of land to Govardhan Benia, grandfather of defendant number 1 and 2, by registered sale deed so-and-so recorded. Then it appears that Howrah Zilla Parishad is claiming to have purchased an area of 36.7 decimals corresponding to LR from me overseas, who in turn is claiming to have purchased portion of the suit property by series of deeds allegedly from legal heirs of Santosh Kumar Dhor and so in the year 1990. And the defendant number 3 is claiming to have retained the balance area 40.3 of residual land in RS plot number so and so. So all these things your lordship will find is mentioned in RS. No LR is mentioned. He refers about deeds by which I'm claiming to hold X amount of property and saying that I'm holding the balance also. It appears the said company have entered into development. Now, this is why the suit has really come about for 30.25 acres in LR plot number. Now it's changed, power of attorney. This, my lord, your lordship will now read the rest of 4. Thus, the area in suit plot by respective deeds and probate comes to more than 79 decimals, which is more than 16 and a share, while the actual area in the plot is 79. The plaintiffs have reason to believe that all such deeds and documents are fake and fictitious, and there is no existence of any valid deed. The purported deeds and documents executed by person or persons have, without having any lawful authority, have no legal existence in the eye of law. The defendants are hereby called upon to produce their respective deeds and documents, including back title deeds, if there be any, executed by person or persons without having any lawful authority. The said documents are required to be furnished for proper adjudication of respective shares, right, title, interest. In any event, in the present suit, learned court is required to adjudicate upon the share, right, title, interest of the respective parties on the basis of valid transfer. So, admittedly, there are deeds which are there which have not been assailed. His right, or the cornerstone of his case, is Taraknath to Amiya Devi as a residuary legatee, Amiya Devi to back. Just for the aspect of ex parte ad interim, please have a look at page 73. My lordships would have noted, Manoj, that this suit came to be filed in 2025. Please have a look at page 73, Manoj. This is 10th May 2022, where I write to them 3 years back how the property has to devolved unto me. 3 years later, a suit is filed. This Bipasha Mukherjee advocate had written this letter on the behalf of the plaintiff. So this is not informed to the court. I'm sorry that I did not know there was an ex parte ad interim, Lord. Otherwise, I would have actually come up with an affidavit so I could show you lots of a few documents, but I'll just indicate this. So 10th May 22. Now I'll show 2 documents, Lord. Your Lordship will allow me to show them. During the lifetime of Taraknath Mukhopadhyay, this property, total landholding that this I have is 172 kathas in this entire place. Why? Because from 1990, my name is recorded in the record of rights. From 1990, I have a full-fledged factory runs there. Now I have given it on rent to somebody. That somebody has been there from 2000. I'm purposely not giving out the name, Milord. But from 1990 to 2000, all khajna, I'm recorded in the record of rights. Howrah Municipal Corporation. In fact, the property has stood acquired also a couple of times where I have received compensation. I have sold a portion of this, the deed that was being shown to you.
Acquired a couple of times.
A couple of times, no acquisition. No, there were notices, but has not been. But all these notices.
Acquired, how could it be a couple of times?
Portions of it.
Requisition can be dedication, but acquisition
I don't
cannot
think that also went through. So the notices have come. Acquisition was dropped. Now, this deed that was being shown to your Lordship is where I am selling a portion of my property, 3.407 acres, not kathas,
yes,
to Howrah Municipal Corporation, the Zila Parishad. Now, one thing your Lordship will see, deed ta dekhan jerate amar deed ta. Lord, by 8 deeds. So, this Santosh Dhoor, through his legal heirs, have sold this property, the entire property of 52 kathas, not just 11.5, 52 kathas, which includes this 79 decimal 11 kathas, to me in 1990. But more importantly, Milord, just to cut off the right that he claims, this property has been sold in 1956 by a registered conveyance, which is recorded in Howrah Book Volume 1 at pages 273 to 276.
But this comprises of a portion of the entire block of land. How much?
Well, I have purchased it by 8 deeds, but Santosh Kumar Dhoor had purchased it in 1956 from Taraknath. So this
from Taraknath?
Yes, this is the entire chain that he calls this lady as a residuary legatee. Well, this can't form a part of that will because the admitted case in the will is this property is not mentioned, whatever is the extent of the property. Claiming on the basis
that is not the admitted case. Where do they admit?
Paragraph 3 of the plaint, page 16.
Yes.
Paragraph 3, last at page 17. Although there was no specific mention of the suit plot in the will, but as per clause 9, the residuary legatee Amiya Devi became the owner.
Yes.
So if Taraknath has sold the property in favor of somebody else during his lifetime in 1956, then Amiya Devi doesn't become a residuary legatee.
That deed was produced by them.
No.
At the ad interim stage, we can look into their pleadings only.
Well, if there is suppression, I'm entitled to show that to your Lordship.
True, but there is a limit to which we can go in.
Well, I'm just showing registered deeds because he admits also then, he admits that there are deeds. If your Lordship is looking at the plaint, I am
says
showing
regarding portions there are deeds.
Yes, so I am showing that portions which have been
Santosh
sold.
Dhoor purchased the entire property of Taraknath.
Whatever has been sold can't become a part of the residuary legatee.
No.
So then that property has to go out. So I am showing your Lordship because he refers to these deeds.
No, he says he admits there are co-owners through Santosh Dhoor. You are co-owners through Santosh Dhoor. He admits that and asks for partition. He does not challenge the deeds.
Well, he does not challenge the deeds.
Although he says in the plaintiff somewhere.
I don't know how the suit is also maintainable in so
Why?
far as his alternative prayer is concerned.
No, that
But
is
that's
not.
for
It is
me
not.
to take it up later.
It is not.
No.
Yes.
So that's for me to take it up later.
Alternative prayer, since it's an alternative prayer, we can ignore the same.
Yes, yes. So I'll take that up later.
He
But-
says that he's part owner of the property and he claims through the Soumya Devi and all.
But that's the point I'm trying to urge. He claims his right from Amya Devi, who is a residuary legatee.
Yes.
So properties that have been sold in the lifetime of Taraknath, there is no residuary for Amya Devi. He claims this property only, my lord. In paragraph 3 of the plaint, I'm just showing the suppression. By 8 deeds from 1990, I am in possession. From 2002, 2022, I put them on notice.
So Taraknath executed a registered will, which was probated in the year 1962.
62. These properties have been sold in 1956 by registered conveyances in favor of Dhar. Otherwise, my lordship will consider that from 1990, if I am there with registered indentures and a party comes to 2025, well,
These are required to be gone into, Mr.
True.
Banerjee. You
But
have to
if-
produce this before the trial court and
I'm going by one aspect.
these are factual aspects. These have to be gone into. But
I am.
if you transfer the property in the meantime, then nothing will remain for the suit to be.
Well, I'm only on this that today. If
Regarding
there is-
possession, we cannot grant injunction. Neither are we granting. The status quo and regarding nature,
No,
character,
that-
and
that-
possession.
I'll tell you, Lordship. Some party has come to court today. Even if I can't show your Lordship the suppression, page 73, just to show that ex parte he is not entitled to.
Yes.
Because, page 73, if your Lordship looks at.
73, yes.
2022, he had knowledge.
Hmm.
Well, today it's all right to just make up a case in a plaint and come to court and say, but he's come after 3 years.
After? When was the
After.
suit filed?
This is 2025.
Which month? 3 years is the limitation.
April, no?
April, it's within limitation.
Yes, this is of P7. আরে কি তুমি উল্টো পাল্টা বলছো সুটটা কবে ফাইল করেছো 2025 February.
February 2025. So
February
within
20
limitation. Within limitation.
Within limitation, but I'm saying one for ex parte, I am prima facie being able to show there is suppression. He has mentioned about deeds. I am there in the property from 1990. The record of rights in my name. The entire property has stood sold. He's come to court only with respect to 79 decimal. Well, taking advantage of the fact that the party ex parte ad interim, I'll have to take the pleadings to be true and correct. But your lordships have held from 2005 onwards. There is a suppression. I'm entitled to show
It has
that.
to be palpable, gross.
Palpable, I'll be able to show, my lord, because the suit property is stood transferred. He claims his right in respect to 79. But even if that is not weighing on this honorable court, I'm showing that from 10th May 2022, he has waited till February 2025. His ex parte ad interim has been refused. He's come after 2.5 years. Gives me 14 days time. I'll bring these documents on record. But this injunction now, my lord, and he pleads that there is a development agreement. A party has to be vigilant. 2.5 years later, he comes and seeks an ex parte ad interim. My lord, your lordships have never countenanced it. The suit is maintainable, but he is entitled to an ex parte ad interim where there are such very disputed questions of fact. That also your lordships have held in 2005, that where the disputed questions of fact ad interim ex parte cannot be granted. I am showing purely from the plaint that he is claiming to be a residuary legatee. That property stood transferred by a registered conveyance in 1956.
Where is the deed?
This is the deed, my lord, by which I have purchased it in 1990. Purota ache? Purota ache 11? Now there are 8 deeds. I'll show one of them just as a prototype.
Original টা দেখান
আপনার copy আছে? My lord, kindly, Justice Kumar will
We will direct you to file affidavits and bring these on record. Bring these on record.
Oh, your lordship will consider
How soon can you file your affidavit?
The injunction will continue to hurt me, my lord. Well, he is not really entitled to an injunction here.
At this stage, we cannot say that. We have to proceed on the plaint.
No, even if I
On the basis
go
of
by
the plaint,
probate, my lord, if your lordship looks at the probate one, my lord, kindly have a look at the probate if it's at all legible.
Yes.
কি দেখা ছিল বলো? My lord, kindly have a look at page
33 onwards, the probate certificates are there. Your Lordship will probably not find the name of Omiya Devi here anywhere. Because it's the name of the executor which is there.
Will must
And
be
now,
annexed to it.
yes, Your Lordship will look at page 33. And in 33, Rajendra so and so, a copy whereof and credits, and in the way concerning his will was granted to Shivani Devi, wife of late Taroknath, old grand so and so, Shukendra Nath Chakraborty.
This is page
33.
Page 47. Kindly see page 47. Go schedule first name.
And even in the record of rights, will not. Oh, Arif, actually, Arif.
47 where?
First.
Omiya Devi Prapta. Yes.
Srimati Omiya Devi Prapta.
Omiya Devi Prapta.
No,
is
that's
there.
the will. In the probate, I don't find it. No? The probate certificate at page 33.
That in respect of that will only.
And
let us see what was given to us. Nijo body, such and such.
This kindly have a look at the deed, Manoj, that I've just handed over. If you Lordship could just have a look at that. So his ex parte ad interim was refused. There's a registered deeds of conveyances which show that I am in. This property has been conveyed to me in
These questions have to be
1990.
gone into it. We cannot have a mini trial here, Mr. Man.
No, I understand. We're not balance of. He has to show prima facie title to be entitled to this.
He has proved shown the probate. The will is annexed to there too. Page 47 mentions Omiya Devi. He claims to Omiya Devi.
He is claiming to Omiya Devi,
Yes.
mentioning in paragraph 3 of the plaint that the property is not mentioned in the will. It's a residuary legatee. That is the point I'm harping on. I am showing that in the lifetime of Taroknath, this property was conveyed to a third party. So the residuary legatee gets nothing. So he prima facie doesn't even establish title to seek anything. All I'm saying, after 2.5
To ascertain whether this entire property was given to them, we have to go through all the deeds. At this stage, ad interim appeal, we'll go through that.
If they're registered deeds of conveyances, then any
Calcutta
party
will
can
consider
come at
that.
any point of time and get an injunction on somebody else's land. He doesn't claim. I could have understood.
At the
his
expert
plain
hearing
case.
stage, may. In certain
I
cases,
could-
they do.
Today, no, that's okay. But today, I'm at a stage where at the ad interim now I've come before the court and I'm showing suppression. He pleads deeds.
The question of suppression, Mr. Banerjee, is not so palpable as you are trying to make it out. Because we have to look to deeds, we have to compare the schedules of each of the deeds with the suit property as well as the probate, which is not possible in an appeal. We don't have the infrastructure in an appeal.
I understand that.
Against an ad interim refusal of injunction.
Yes, but
Definitely
I'm only with one aspect. Bear with me for 2 more minutes. Only on one aspect, that he has to first establish prima facie title.
Yes.
His prima facie title he claims through Taroknath. Taroknath mentioned in paragraph 3 that the will does not mention this property. So he is also sort of creating and kind of an illusion saying residuary legatee. I have produced one registered deed of conveyance which shows the property was conveyed.
Filed opposition, Mr. Banerjee, come back. Disclosure. No. The heard learned counsel for the parties. Their own document annexed here. Which page?
এটারই কথা বলছি আমরা এটারই কথা বলছি
Milord, this should not be confused with Kobala. It's Kobluti. That's annexed there. This is the original. It's very much legible. It's that was a short term, Milord. What there my learned senior friend is saying.
Kobuliyat, where is the Kobuliyat?
Yes, Milord. It's there, Milord. In the original, your Lordship can see, Milord. It's the Kobuliyat. Now, Milord, which was given to Dhors. Which, Milord, the Kobuliyat means, Milord, it's a lease for a Milord for a.
Kobuliyat is not a Kobala.
It's not a Kobala.
57 এ মারা যায়
No, that is Kobuli, and we have it.
হ্যাঁ কবুল করছে হ্যাঁ
Original.
let us come back tomorrow. Today we have a different bench to after. Banerjee, file your written oppositions have come.
No, Malad,
Certain arguable questions on fact have been raised by the respondents. Full stop. Learned counsel appearing for the respondent numbers, senior counsel appearing for the respondent numbers 1 and 2, and learned counsel for the respondent number 3 seek to rely on certain documents and content that there has been gross material suppression while obtaining the ad interim order in this court. Push up next para. However, comma, although learned counsel for the respondents submit that the ad interim order ought not to be continued, comma, we find that we had granted ad interim order at the ex parte initial stage upon being prima facie satisfied of the case made out in the injunction application, full stop. Hence, comma, it is doubtful as to whether how far a court, comma, sitting in a miscellaneous appeal over ad interim refusal, ad interim injunction prayer refusal, comma, can enter into the merits of a case unless they are so palpable that uh, detailed examination of factual aspects of the matter are not gone into, are not required to be gone into. So be that as it may, comma, since since the respondent seeks to rely on documents in support of their contentions, comma, the respondents are directed to file their affidavits in opposition to the application within June 13, 2025. Reply, if any, shall be filed by June 20, 2025. The application shall be listed on June 23, 2020.
Can it be on
Affidavit is filed today,
June 24?
June 23 to June 24.
Item number 27.
Yes.
Mr. Gupta was my other side. Perhaps your lordships may not be able to take it up today.
No, we won't be able
Your
to.
lordships are not sitting.
No, I'll sit singly. We are sitting singly
The
separate.
only difficulty is when the execution case is tomorrow. If your lordships can prevail upon Mr. Gupta to keep
I
it
prevail
alive.
on you. We prevail on you. Don't do anything.
Only for tomorrow. No? Only for tomorrow we shall come.
Till we take it up.
No.
We are passing an order.
Tomorrow.
Execution case, what is the stage with the execution
I
case?
think the bailiff has been asked to hand over or something. It's at
They are
the
coming
very-
after 6 years. So, my lord,
Because you have levied execution after 6 years.
no. Execution was levied then and
We
there.
manage the bailiff after 6 years.
taken in 23. Decree also
Come back tomorrow, let us see.
Great.
Yes.
Mr. Agarwal is there.
With your lordship's leave,
Yes, Mr.
Lords, my learned friend, Mr. Raju
Mr. Agarwal, before you proceed, Mr. Banerjee, you and Mr. Bhattacharya will submit over and above Mr. Agarwal.
Yes, afterwards. Not immediately. Your lordship. Here's Mr. Agarwal. I think.
No, because the other aspect is Mr. Agarwal. We have to hear the petitioners first because otherwise it will be piecemeal.
Right, Lord. So, Lords, I had a suggestion.
Yes, Mr. Agarwal.
Because when we began yesterday, we did a short submission from an opening perspective.
Right.
After hearing my learned friend, Lords, your lordships indicated that your lordships would want to hear the entire matter once and for all.
Yes.
Because my petition in part is based on my challenge in the CBI matter, which is coming up on 4th of July. I have a request for your lordship's consideration.
Yes.
Please don't pass any interim order.
Huh.
Place this matter for final hearing along with that matter on the 4th of July. Because if your lordships were to agree with me in that matter, my challenge will survive here. I will still have to make good my challenge here. If your lordships decline my challenge in the CBI matter, my portion of the petition which deals with that issue will become infructuous.
Huh.
So otherwise what happens is that today if your lordships, and I say this with utmost respect, your lordships actually will not be able to decide this matter finally unless and until that matter is decided. So in that context, my request is that matter is coming up on 4th of July. Please don't pass an interim order. Please have it on 4th of July. We will come physically.
If you don't insist upon any interim order in all these matters, then Mr. Raju, we can consider hearing that matter along with this.
Yes, I have no objection.
Very
If
well.
no interim order passed, I have no objection. Matter is adjourned to 4th.
So we can record that and keep it on the 4th of July.
That's right. And my request would be, please, we'll do it finally. There's no difficulty.
Yes.
At least we'll have the ability, because a lot of arguments is about whether that order or that CBI issue is correct or not. So let's argue that. We will.
Mr. Raju has an independent case also apart from the
That's
CBI.
right. Absolutely.
But even then, that is one of the components definitely.
I'm obliged. So I'm
not
saying
that the EDI investigation challenge is entirely dependent on that, Mr. Agarwal.
I agree.
EDI has independent things also.
I am putting it this way.
Yes.
If I lose my CBI challenge, then my part of the petition, which is predicated upon that argument, fails.
Right.
Without opening a single word.
Right.
If I succeed in the CBI challenge, then I still have to surmount the argument that Mr. Raju has made that it will have an impact on the ED case.
Yes.
So I am conscious, of that. All I'm saying is that because that matter is really the edifice, your lordships may have it along with that.
Very well. Then we can do that then. So, so I'll record consent of all parties that this matter will be taken up along with the other matter on 4th of July for final hearing.
Yes.
If you agree to that, all of you.
I'm most of that.
Only thing is that your lordship will not indicate that as far as the interim order is concerned, then also we can make a prayer at that stage. If
that will be left open.
If required, it will be left
Won't say anything on interim order.
That's all.
I'll only record this much as I indicate.
That's
So that may prejudice me or someone else.
Only with the leave of my learned senior.
Your lordship only.
The trial court matter is fixed tomorrow, 21st. So
will not pass an interim order.
There is no interim order.
That this pendency will not depart because, my lord, what happens? We have the experience. Always the trial court says the judicial propriety.
That will be virtually a refusal of the interim order.
Yes,
that's right.
And so I'll go neither way. I mean,
grateful,
neither say that
grateful,
using nor
my lord, no.
If there is no impediment in law, you proceed.
My lord, trial court always says this judicial propriety. High court is hearing one matter. I should not proceed.
It does, but if you say that, then it will be tantamount.
There are two bail petitions. What I am indicating, my lord, there are two bail petitions. If this pendency is having, if tomorrow
whatever happened in court today, you can tell the court.
My lord, kindly have a look, my lord. It's all right. My lord may pass the order.
Well, thank you, Mr. Yes.
Please.
On consent of all parties, let all these matters be listed on July 4, 2025. Should we keep it at 2?
I'll be obliged, if your lordships were able to.
At 2 p.m. for being heard along with what is the number of the other matter? Please,
we'll give the number.
That will be recorded. The number of the other matter will be recorded. So we are taking these up on 2 p.m. On 4th of July.
My lords may record my name and Mr. Zoeb Hussein's name. Both We are representing the AD.
Definitely, Mr. Raj.
Regrets.
Whoever is there, just give their names also, your senior's name.
Yes,
Mr. Raju is there, so many others are there. Mr. Agarwal is obviously there. And Mr. Hussain is there probably. Mr. Zohaib Hussain. Or he was the voice on the last voice over on the last.
Everybody's name is reflecting yesterday's order.
Yes, very well. Ota copy paste.
Everybody's.
Very well. Give the name of the other new matter which will come upon.
Yes, the WPA numbers.
That is WPA 7875 of 25 and connected matters.
We will give a slip.
Right.
I'll do that.
We will give a slip.
There are 4 WPA.
We'll give a slip.
Thank you very much, all of you. Thank you. This
I'm
matter is
more-
That is the reason why, my lord, I indicated that we don't want to say anything
Yes.
further.
একটা অর্ডারের কপি দিয়ে দিচ্ছি ম্যাডাম আপনাকে
Grateful, my lord.
Thank you. Thank you.
My deeply obliged.
এবার রেগুলার লিস্ট এই জন্য রেগুলার লিস্টে ছাপতে বলেছিলাম কেউ থাকবে না
Will my lord be taking up the part hard hearing matters today before the, because today's list, one supplementary list has come up.
Yes, we'll take up these matters only.
The supplementary list matters.
Yes.
That there is a part hard hearing matter. This side of vacation where we.
In this.
That Hanuman cotton mill in this list, yes. Yes, yes.
Yes, we'll take up because we have nothing else to do.
My lord.
So please be there.
Then I will come back.
Yes, do.
Deeply obliged.
Call. Not today. Acha, none appears for the parties at the time of call. Let the matter stand adjourned for the day. শুক্রবার আবার থাকবে এটা এগুলো সবই শুক্রবার থাকবে সেম একই লোক কালকে লিস্টে বললাম ছেপে দিতে না ছেপে দিলে এই হবে কেউ থাকবে না কি করে জানবে ওরা আজকে কজন বারে বসে থাকে none appears for the parties adjourned for the day same Passover Passover 11টা আবার কল করে দিন ফাইলটা রেখে এটাই টোটাল আমার লিস্টে ম্যাটার বাকি আছে জাস্ট ছাপলেন না বলে আজকে পুরো উঠে যেতে হবে সারাদিন ওয়েস্ট জাস্ট আপনি ছাপেননি বলে লিস্ট ডেকে নিন আর্দালিতে ডেকে আছে কেন চলো তোমাকে নট চলো